schedule. So we are going to take a lunch break again around 12:30. We're going to end about an hour early this afternoon at 4 o'clock. On Monday, I mentioned this before, but I want to mention it again. We're going to start at 11 o'clock a.m. on Monday. We have staff conference that begins at 10 o'clock. So please do not come into the hearing room until staff conference has been completed. So with that, are there any preliminary matters that we need to address before we get started? Yes, please proceed.
Good morning, Justin Simolovsky on behalf of North Carolina Sustainable Energy Association. When it comes NCSEA's time to cross the long lead panel, I am going to ask leave to add a potential cross exhibit that was not in the binder. It is an earlier version of an exhibit that is in the binder and is directly related to SIGFR long lead and pump hydro storage exhibit 1. I also just want to give the commission notice that I only was able to get 4 copies from the printer this morning. So if that's going to be a problem, I'm also going to ask leave to continue that line of questioning on rebuttal, if that's more appropriate.
Are there any responses from any of the parties? Yeah.
No objection.
Okay. Okay, so I hear no objection. However, if you only have 4 copies, we are not going to have that exhibit discussed or asked to be identified. If you would like to have the exhibit considered by the commission or proffered, you need to have copies for the court reporter and all of the commissioners. So we are not going to accept an exhibit that does not have sufficient copies for the commissioners. You have an opportunity to provide that information at a later time with a later witness if you don't have the sufficient number of copies.
So just to clarify, President Commissioner, when this panel returns for the rebuttal testimony, I would be able to satisfy those conditions?
You may, you will have an opportunity to identify any exhibits that you believe are relevant to the testimony of the panel. So long as you have, I would say, go ahead and file your exhibit and then have copies for all of the commissioners and the court reporter at that time. And at that point, you can identify exhibits and we will have an opportunity to see if there's any objections to the exhibit.
Okay, thank you.
And Presiding Commissioner Kimmerite, if I may be heard briefly, we do not have an objection. However, we would ask for an opportunity to see the exhibit before he engages in his line of questioning on rebuttal. And I understand you instructed him to file an exhibit in the appropriate docket, and that would be fine so long as it happens in advance of the rebuttal panel coming onto the witness stand.
Yes, thank you, Ms. Cresson. That is what I had instructed, that to file the exhibit prior to the time that you are planning to identify the exhibit.
Sorry, one more clarifying question. Would you prefer that exhibit be filed in the 190A subdocket or the master docket?
Please refer to our procedural order. It provides information about how exhibits are to be filed in the docket. So it is, there's sufficient instruction and it's clear in our procedural order. So comply with the instructions in that order.
Thank you.
Any additional procedural matters? Okay, with that, let's proceed with cross-examination of the panel. And I believe it is Mr. Smith with Environmental Defense Fund.
Good morning. Again, my name is Ben Smith. I'm going to be asking some questions on behalf of my client, Environmental Defense Fund. Mr. McIntyre, yesterday you testified regarding the processes that Duke needs to implement prior to moving forward with the procurement of offshore wind, namely following the initial offshore wind study and additional ARFI process, and then, if requested by Duke, an order by the Commission, a procurement process. Mr. Capps, I noticed a stark difference between that and the advanced nuclear requests, where Duke requests upfront development costs to move forward on advanced nuclear. Can the panel explain the differences in approach there?
I mean, I don't know about explaining differences in approach. I can explain why we feel like the approach that we're taking in nuclear is an appropriate path. I mean, the path we have pursued is to do deep dives, multiple deep dives on the available technologies. There are only 4. And then once we pick a technology or pick a reactor, then we'll go through a process to establish an EPC contract. So that is the more typical approach. It's really the general approach that has been used for you.
Yeah, and I would offer just a little bit of a distinction between nuclear assets that the companies would seek to construct and deploy in the jurisdiction to offshore wind. One of the advantages that we have as it relates to new nuclear is we already have and maintain site control over facilities where we would seek to site new SMRs. And those sites enjoy existing transmission, existing access to rail and other infrastructure. So there's a distinct difference between siting, I would say. We do not currently own a WIA, as you know. And so in order for us to contemplate development of an offshore wind facility, we've also got to contemplate how to actually have access to a wind energy area. And do we have access to that via a lease transfer and then an EPC sort of procurement, or do we follow a build and transfer sort of model? So I think there's just some distinct differences between the company's endeavors as they relate to new nuclear and offshore wind.
Thank you. That was a helpful answer for me. And I guess, I don't think it's fair even to compare the technologies, but a distinction I notice is that new or advanced nuclear is not yet commercially deployed. Duke calls offshore wind on page 37 of chapter 2 of its application a scalable and increasingly cost-effective zero carbon resource. And so I guess all things equal on siting and transmission, you'd say that, it would probably make more sense to advance on offshore wind as just looking at the characteristics of a more mature generation resource.
Objection. May I be heard?
Mr. Drack.
Mr. Smith just testified and there was no question asked at the end of that. So I'd ask that the question being asked be clarified.
Okay, Mr. Smith, be sure that you are having a specific question that is directed to the panel, please.
Okay. Subject to check on page 37 of chapter 2 of the application, Duke refers to offshore wind as a scalable and increasingly cost-effective zero carbon resource. Is that correct?
That's correct.
And there is not any, as I've heard you testify yesterday, and I apologize for retread, but I want to make sure I understand it. There's not any commercially available advanced nuclear as described in Duke's application that is commercially working right now.
That's correct.
So all things being equal, offshore wind is a more mature generation resource.
I mean, I wouldn't characterize all things being equal. I don't think they are equal. I would characterize offshore wind as a mature technology globally. But as I noted yesterday during my testimony, there are less than 500 megawatts of offshore wind operating today in waters off of North America. So while yes, one could call offshore wind mature at the global scale, I characterize offshore wind as continuing to be nascent domestically. The other thing that I would point to is the fact that the companies are always aspiring to be in lockstep with this commission. And pursuant to the order from the original carbon plan, we are moving in what I believe to be a manner that is entirely consistent with that. Notably, the ESP work and the portion of that original order that directed the companies to begin pursuit of an ESP for new nuclear. And I believe that we have satisfied the conditions of that order with our original WIA analysis. And we think that pursuing offshore wind in the manner that's described yesterday is entirely appropriate.
The other thing I would add, just to have the right context, is while there are no small modular reactors operating commercially in the U.S., the technology is the same technology that's used in the large light water reactors today. So if you look at, you know, the design, the technology, the moderator, the fuel, there are 94 plants operating in the US today that use the same technology. So it is not novel in terms of the ability. Doing it on a small scale is different, but it's not unproven by any means.
Thank you. So I want to ask a little bit about how Duke plans for long lead resources. Because yesterday I heard some interesting questions. And so I'll start there, or some interesting answers. I'll start with, can you give a brief explanation about how long lead resource planning occurs within the Duke walls and how they sort of start to assess different generation types and additions to the grid?
I can speak for Bad Creek too. Again, when we started seeing the significant amount of renewables that would be coming on the system, started looking into what storage technologies would be available.
Mr. Smith, can you speak up or a little bit more into the microphone, please?
Sorry about that. Again, from a Bad Creek 2 perspective, you know, when seeing the significant amount of renewables we were expecting on the system, started looking into what availability we would have to potentially add more pump storage to the system and started that process. And it was around the 2019 timeframe that we started looking into the potentials for new pump storage at Bad Creek.
And I mean, specific to nuclear, you know, once we started down a path to reduce carbon, then from a system operation standpoint, in order to have carbon-free baseload generation, dispatchable generation, then nuclear in some fashion has to be part of that mix. So that's what kind of got us started, and then you know, you look at the technologies, the vendors that are available, and we went through a screening process and you know, pared it down to the technologies, the vendors, and the paths that we're considering today.
Thank you. Mr. Smith's Bad Creek 2 answer brought me to, it sounds like you look at what the assets that are currently on the system and that are going to be on the system in the future as part of your assessment. Would it be fair to say that you try to complement some of the other assets that are already on the system?
When possible, I think that would be the case.
I think what you're describing, frankly, is the resource modeling process, and I think our modeling panel would probably be better suited to address that specific question.
Well, Mr. McIntyre, do you recall being quoted in a March 24th article in the Raleigh News and Observer saying, "We know North Carolina being a winter peaking state, we can't count on solar in and of itself when we are experiencing that peak demand before the sun comes up in January. The beauty, particularly of an offshore wind resource, is it complements our system well."
I do recall that, yes.
So I guess that's sort of where I'm coming from, is your knowledge there.
As I think the commission and parties to this proceeding heard yesterday from a number of panels, we have acknowledged that there is one advantage that offshore wind plays, and that is it can deliver energy across the winter peak. I don't think anyone has disputed that. And so you're correct when I believe our resource modeling team is evaluating opportunities. You're looking at how to balance the system and meet a variety of objectives, and you know, looking at assets that can complement those that are on the system today as part of that process.
Thank you. And Mr. Capps had referenced the decarbonization that the companies are seeking out. As you look forward to giving recommendation to the companies about long lead resources, are you all talking about House Bill 951 and the 2030 requirement for a 70% reduction, or the carbon neutrality requirement in 2050?
I mean, as Mark said, the modeling folks facilitate the process. They come to us with questions and ask for input, and we provide input to that process. And then they ultimately take all that input and produce an output that turns into the plan that we're talking about at this point in time.
Okay, so you all are sort of helping to populate what ends up being the modeling outputs in some way, shape, or form.
In an input form.
Okay. Thank you. That was very helpful. Mr. McIntyre, yesterday you testified about the differences between the statutory constructs of Virginia and North Carolina. Do you recall that?
I do.
And one of the things that you pointed out was the offshore wind requirement for Virginia, isn't that right?
Yes, I believe I did.
And were you aware that the implementing portion of the Virginia code for that offshore wind statute begins in order to meet the Commonwealth's clean energy goals?
I'm not aware of that language specifically, no.
Okay, so subject to check, Virginia Code Section 56-585.111 begins before going into offshore wind requirements that this is in order to meet the Commonwealth's clean energy goals. Is that right?
Subject to check.
So isn't it a fair comparison to House Bill 951, which requires the carbon reduction that we've talked about already?
I don't think it's fair at all to compare these two pieces of legislation because I believe that they are fundamentally different from each other. In the case of House Bill 951, as I noted yesterday, and as I'm sure you are aware, with the exception of the carve out for solar, House Bill 951 is a technology agnostic piece of legislation. One cannot say that about the Virginia Clean Economy Act because it specifically identifies the procurement of offshore wind. So these two pieces of legislation are markedly different as it relates to the pursuit of decarbonization in the energy sector.
But they're both seeking carbon reduction.
I think that's a fair statement.
I want to know a little bit, I want to talk a little bit about developmental costs. In terms of long lead generation, two of the technologies, nuclear development, particularly advanced nuclear, and then Bad Creek 2 pumped hydro storage are seeking upfront developmental costs in this proceed, or they're seeking the commission to approve for planning purposes, the ability to seek out upfront developmental costs. Do you all think that if offshore wind is ultimately selected by the commission, that the companies would be interested in pursuing developmental costs for offshore wind?
Just a couple of comments. The companies are not an offshore wind developer. We do not hold a wind energy area lease. We do not have anything to develop at this time. So in contrast to other resources, what would we be developing if we don't have a lease to develop? I guess I would leave you with that question.
But you don't yet own a small modular reactor yet, do you?
No, we don't.
Regarding the Kitty Hawk North, Sea Vow South sale from Avangrid Renewables to Dominion, Virginia, Mr. McIntyre, I believe you testified yesterday that while there are statutory differences between the states, there are things that Duke might be able to learn from that sale to Dominion. Isn't that right?
I believe I was trying to represent that there are lessons that the companies can learn from anyone that is in the process of developing an offshore wind facility.
Sure. And Mr. McIntyre, are you familiar with the Southeastern Wind Coalition?
I am.
And are you a board member of that
I am.
organization?
Yes.
Does Dominion have a board presence on that?
I believe they do. I can't say with definition, but I believe they do.
And do you think that the common board experience there could provide an inroad to gathering information to the extent publicly available on how Dominion went about purchasing Kitty Hawk North? I
would include board service on an organization like Southeastern Wind Coalition among those things that involve monitoring the marketplace. So, in a short answer to your question, yes. And on that same line of thought, are Jen Banks from Total Energies and Scott Cronin from Avangrid Renewables board members of the Southeastern Wind Coalition? I can confirm that Jen Banks is. I do not know the individual that you mentioned from Avangrid. Okay. Mr. McIntyre,
in 2016, I found an article in the Charlotte Business Journal that John Downey wrote that you described that the company was anxious to take a collaborative approach to reducing carbon emissions by 2030. Is that still the case today?
May I be heard?
Yes, Mr. Drack.
This is the second time Mr. Smith has introduced an article. I'm not clear if it's an article that was included in his potential cross exhibits. On the second attempt, I'll object out of principle to the quoting of articles regarding which has not been provided as a cross exhibit, nor has a copy been provided to Mr. McIntyre.
Mr. Smith.
Well, first, I didn't know Mr. McIntyre was going to be the witness until recently. And so my gathering of materials came late in this process. Secondly, I'm happy to rephrase the question to take out the quote.
So, Mr. Smith, yes, please rephrase the question. If you do not have copies of exhibits that you've already filed in the docket, then please refrain from asking questions about potential exhibits that have not been provided yet. So if you can rephrase the question.
Sure. Mr. McIntyre, in your work at Duke Energy, have you ever felt anxious to take a collaborative approach to reducing carbon emissions by 2030?
I'm not sure that I would utilize the word anxious. However, I think the article that you were referring to, and I'll address it directly, was a quote that I made relative to EPA's original Clean Power Plan. And that Clean Power Plan, as this commission knows, was a federal effort to constrain emissions from fossil emitting sources. And so in that context, we were interested as a company in working collaboratively with our environmental regulators in the state to support their efforts in developing a rule in compliance with that Clean Power Plan that we felt was implementable. And so I think it's important that that context be considered by the commission in this particular case.
Thanks. And do you think it would apply to, as we continue to try and reduce emissions in the state, that collaborative approach sort of principle would still apply today?
I would say that external engagement and collaborating with folks that who have a vested interest in this business is a tenet of our work. We aspire routinely to collaborate with customers, with customer advocates, consumer advocates, environmental NGOs, social nonprofits, this commission, the public staff, and others. So collaboration, I believe, as I noted, is a tenet of our work.
And do you think a collaborative approach to developing offshore wind would be helpful for the state?
I think a collaborative approach in general is productive.
No further questions.
NCSEA is up for cross-examination.
Thank you, Presiding Commissioner Kemmerite. At this time, I'm going to ask my colleague to approach and bring up our binders. And while he does that, I'm going to do my best to follow the commission's directive and not cross the line. Mr. McIntyre, I would like to revisit SIGFR's long lead and pumped hydro storage panel cross exhibit 1. It was pre-marked as NCSEA potential cross exhibit 85. I believe that should be in volume 83.
Yeah,
volume 3.
It's going to take a moment to get to that.
Thank you, sir.
Can you identify the exhibit again, please?
You said 85?
Yes. SIGFR cross long lead and pumped hydro storage panel direct cross exhibit 1.
Okay.
And it was.
And what was the potential cross exhibit number?
It was pre-marked as NCSEA potential cross exhibit 85.
Okay.
Okay, I believe I'm there.
Okay, thank you. Ms. McIntyre, do you recall being asked questions about page 20 and a bullet point stating reduce the cost of fixed bottom offshore wind energy to $51 megawatt hours by 2030 from a 2021 baseline of $73 megawatt hours as a federal goal.
I do.
Can you now flip back to Roman numeral IX in the front of the,
On the very, very front of the document?
not
or-
the very front, about 9-ish pages in the Roman numerals.
No, it's going to be. Okay, I'm there.
IX. On that page, do you also see the same near-term offshore wind goal, reduce the cost of fixed bottom offshore wind to $51 megawatt hours by 2030 from 2021 levels of $73 megawatt hour?
I do.
And do you see that there's a footnote 19 attached to $73 a megawatt hour figure?
I do.
And that footnote reads Staley T and P Duffy 2022-2021 cost of wind energy review.
I see that.
Great, thank you so much. Per the commissioner's directive, I'm gonna do all the appropriate filing up activities to identify this as a additional exhibit for NCSEA, which I will give you, the commission, and the court reporter an opportunity to review, and I will come back to that on rebuttal. Mr. McIntyre, I'm going to give you a break. I'm going to come back to you a little later after that. So, Mr. Capps, I'm going to have some nuclear questions for you, please.
Okay.
Could you please turn to the direct testimony of the long lead panel, pages 21 and through 22, please?
I got a new copy because of the challenges yesterday, and I can't find the new copy.
Got it right here.
Thanks, sir. Yes, sir, I'm there.
Great, thank you. And on the top of page 21 is the question, what were the commission's findings in the carbon plan order regarding Duke Energy's proposal to incur project development costs to pursue advanced nuclear technologies? And the answer is on page 22, correct?
Not exactly, but I'm with you on the question.
Okay. Well, in the answer, at least, you describe how the companies have complied with Commission's directive to pursue up to $75 million in early development costs.
That's correct.
And on page 23, table 4 is a estimated cost for advanced nuclear that the companies is seeking to request authorization to incur through 2026, correct?
Yes, sir, that's correct.
And Mr. Capps, we are also having a little bit of trouble hearing you, so if you can speak a little bit more directly into the microphone, please.
Yes, ma'am.
Thank you.
And may I clarify one matter?
Mr. Drake,
Thank you.
proceed.
Again, I think the witnesses have in front of them the updated version accepted by the commission on July 22nd with Mr. McIntyre added to the witness, to the testimony. I believe that's the copy they have in front of them. The page numbers and references, if you're looking at the older version, will not match up. So if you have the newer version available, I think it would assist all parties in following the page number and line references.
Thank you. I thought I did my best, but I'm confident that table 4 is still on the top of page 23. So, Mr. Capps, that table for the seeking to incur $365 million to be incurred through 2026, that is $365 million across 2 sites and 6 units, correct?
That is correct.
So between the authorized amount from the initial carbon plan and the estimated costs in table 4, ratepayers will see approximately $440 million for 6 units. Correct?
That is correct. The 75 million plus the additional 365 million being asked for in this proceeding.
Thank you. And that $404 million through 2026 does not cost any construction costs for the advanced reactors, correct?
Construction cost in terms of physical site work, pouring, safety-related concrete, no, it is
Okay.
not. There are physical things that have to be done. For example, to permit a site, you have to build a meteorological tower, you have to collect data in order to support the permit process.
Thank you, Mr. Capps. And just to be clear, if you look at the furthest column on table 4, you'll see a 0 value in 2 of those rows, correct?
That's correct.
And if you track that directly to the left in the activities column, that 0 correlates to construction.
That's correct.
So understanding if there's physical early development activities going on, there's no actual construction pursuant to a joint construction and license.
That is correct. You have to get through the permitting process and the licensing process in order to start construction for a nuclear unit.
Thank you. And the big number in that third column is $220 million for, when you track left, reactor technology vendor initial fee and long lead equipment, correct?
That is correct.
And that only appears for Site 1?
That is correct, based on the timeline.
Is it possible that a similar large figure of that magnitude will appear for future sites?
Yes, that is possible.
Okay.
Particularly the long lead equipment. I mean, every unit's going to require long lead time equipment.
Thank you. So, understand the companies have not selected a reactor technology yet. Each unit is projected to be about 300 megawatts electricity.
300 megawatts is the number that we've used from a planning standpoint. The actual megawatts would be dependent on the technology selected.
Okay. And in total, how many units of advanced nuclear reactors have been selected or are being planned to be constructed by the companies at this time?
I believe if we go back to the modeling section, there are 18 small modular reactors that are nominally 300 megawatts each, and there are 13 advanced reactors that are nominally 450 megawatts each.
And just to clarify, were those selected or were those available for selection? Or is that something I should ask Mr. Snyder?
I would say that is more a modeling question in terms of the mix and the selection in the overall scheme of things.
Thank you. Mr. Capps, can you go to, it's going to be in volume 5 of NCSEA's exhibits. It's going to be one of the last tabs in the back of the binder. Tab 213, please.
Oh, made this difficult.
Yeah, 4 belts and 7 suspenders. So, and I still missed one.
You said 213?
Yes, please. Okay, thank you. Presiding Commissioner Kemmerer, NCSEA requests to mark NCSEA potential cross exhibit 213 as NCSEA cross long lead generation and pump storage hydro panel direct exhibit 1.
It will be so marked.
Thank you. Mr. Capps, can you confirm that this is Duke Energy's response to SACE request number 3424? Should be in the upper right-hand corner.
Yes, sir.
Thank you. And Mr. Capps, this data request asks whether the P3 plan includes the start of commercial operation for the number of new nuclear reactors between 2035 and 2049 as given in the table below. Is that accurate?
Yes, sir.
And these, this table between 2035 and 2049 complies with the new selection, resource, and modeling where only two sites can be built two units can be built contemporaneously. But this table identifies 29 units through 2049, subject to check if you don't want to count.
Understand 29 subject to check.
Thank you. And is it to be understood if there are approximately 30 units, we're looking at 10 sites for small modular reactors?
I would not assume that.
Okay.
I mean, the number of reactors you can put on a site is really dependent on the specifics for the site in terms of land, water, the support equipment that you need, or the support that you need for the site. I mean, you could conceivably have sites that would have less. You could have sites that would have more. I mean, if I were generally going to say, you know, pick a number, I would think 6, just for a number to talk about and trying to maximize the benefit of the economies of scale. We would try to target at least 6 reactors for a site. That may not be possible in all cases, but it would be a target to work to.
Okay, thank you. And just for the record, can you read the one-sentence response to this data request, please?
The companies confirm that the resource availability for new nuclear listed in the provided table matched the resource availability used by the companies in the supplemental planning analysis.
Thank you so much. And did you see any portions of NCSEA's cross-examination of the IRP and near-term actions panel a couple days ago?
I did not.
Okay. Subject to check, would you agree that Mr. Snyder confirmed that an AP 1000 was not a selectable resource modeled in this carbon plan IRP?
Subject to check, I would agree.
Thank you. And could many of the incremental units that you identified earlier, potentially around 18 small modular reactors, could some of those incremental units be avoided through a larger baseload nuclear generating facility like an AP 1000?
I mean, sure, it's just a math problem, right? It's 11,250 megawatts. So if you build a plant with 300 megawatts capacity, it's that divided by 300. If you use 1,100, it's that divided by 11.
But the companies have not done that math problem, as an AP 1000 was not a selectable resource yet.
That is correct.
Great, thank you. And the WS lease site permit, that is still active, correct?
That is correct.
And the AP 1000s proposed for that site before they forestalled were approximately 1,100 megawatts, subject to check?
That is correct.
Thank you. And thank you for answering those questions regarding economies of scale in terms of unit size. Now I'm asking a question about the staggered approach to construction, limiting to no more than 2 units per year. What's the contingency if there are delays for any one of those units?
So to be clear, there would be 2 units coming online per year, but there would be construction on multiple units. I mean, the construction period is, we've generally said 36 to 42 months. So to get 2 units online per year, there would be, there would be construction happening in parallel once you started at the first site, the second site, the third site, to support bringing 2 units online.
So just to understand, and I understand this is a hypothetical, if there is a delay at unit 1, could that cascade and delay unit 2 and subsequent units after?
I can't answer that
Okay.
question. It totally depends on what the delay is.
Okay. And if there is a delay, could that lead to a generation shortfall?
I can't answer that question. I mean, that's more a system ops question in terms of, what would things look like in the 2035 to 2050 timeframe.
But in a planning perspective, if some of these small modular reactors don't come on as projected, there's nothing currently backfilling them other than the offshore wind that the low nuclear variant identified.
I think from a planning perspective, if we were to get in that time frame and have counted on that generation, then certainly we would have to accommodate it in some fashion.
Okay. Mr. Capps, may you now please turn to page 15 of Appendix J.
Yes, sir.
Thank
I'm
you.
there.
Thank you. The first full paragraph on page 15 reads, "To significantly reduce both financial and regulatory risk, it is preferred to be a close follower to these first-of-a-kind projects, allowing the first-of-a-kind projects to resolve many of the initial design and construction risks." Did I read that correctly?
Yes, sir, you did.
Thank you. And the paragraph continues. A balance must be achieved to ensure that Duke Energy's first plant remains a close follower and does not overtake the first-of-a-kind projects to begin taking on those first-mover risks, but falls close enough to meet new generation needs. Correct?
Yes, sir.
Thank you. Although it is the company's preference not to be first, they cannot control the decisions and development activities of other utilities, correct?
That is correct.
And how do the companies avoid not overtaking the first-of-a-kind projects? And I believe you identified the Tennessee Valley Authority project at the Clinch River site yesterday.
Yeah, I mean, I think, it's our goal to be a fast follower because we feel like that's a more appropriate position to be in terms of managing the risk. But as you said, we cannot control the external environment. We cannot control the pace that others work to. So while we would not choose to be first, if you play this out over 4, 5, 6 years and get very far into it, we could potentially find ourselves being first through no decision or no action of our own.
Okay.
It's possible.
And so if circumstances do change and that Tennessee Valley Authority, Clinch River site, one of the ones currently ahead of Duke in their planning processes, if circumstances change and Duke Energy in North Carolina assumes the pole position, what measures are the companies contemplating to mitigate those first mover costs and risks?
I mean, I think it would really just be working with the vendors and the constructors and making sure that as we got into it, that we had a complete design, that we had a workable design, and that we had a good plan going into it, to be able to execute. And I mean, I think that would be the case for first of a kind nuclear. It would be the case for any large infrastructure project. I don't know that it would be any different.
Okay. And in answering an earlier question of mine, I mentioned the new sequencing pattern that the companies will be adopting by developing site 1 to its completion before moving to site 2. And the company identified that there will be learnings from each unit on that site, correct?
Yes and no. I mean, subject to check, I don't think the path is to develop site one completely before moving to site two. Subject to check, I believe the plan is to develop the first two reactors on site one before moving to site two.
That would make sense logically to continue that staggered approach. So I understand that. But thank you for clarifying that. So there will be learnings by moving from your units, but if Duke Energy takes the pole position, that means that that first unit, there's no learnings to rely on, either internally or externally from other utilities that may have gone through these processes first.
I would disagree. You know, beyond TVA and Clinch River, Ontario Power Group is building a small modular reactor in Ontario that should be in service well ahead of Duke's plans. And then, you know, beyond that, the Vogtle 3 and 4 units that just finished, while not a small modular reactor, same general philosophy in terms of modular construction, and a tremendous amount of lessons learned from that plan that can be applied to our plan. Likewise, the two advanced reactors that received a significant amount of government cost share funding through the ARDP would both be finished ahead of our plan. And there would be significant lessons to be learned from those. So I think there's ample opportunity for us to have lessons learned and move along on the path that we have laid out.
All right, but so Duke will be a second mover on an AP 1000, and those lessons learned more directly correlate from the Vogtle experience, correct?
I wouldn't just take the Vogtle experience and put it in the context of an AP 1000. I think the Vogtle experience can be applied much more broadly than just an AP 1000. Certainly it applies to that, but it would apply to any modular construction of a reactor. Similar to, you know, the construction in Ontario for a GE BWRX 300 oil and water reactor, or the two advanced reactors. While we may not build the exact same technology, there'll be significant lessons learned relative to the construction that will be able to be applied.
Thank you. And my last question is just to confirm that there is still no advanced reactor technology that has gotten design approved by the Nuclear Regulatory Commission at this time?
For an advanced reactor, that is correct.
Right. And I would like to qualify that. I understand that the NuScale project did get through the design phase, but the current active projects have not reached.
All right, let's go back. Ask the question again.
Yep, thank you. So aside from NuScale, which did reach its design approvals from the Nuclear Regulatory Commission, the Clinch River project technology has not received its design approvals from the Nuclear Regulatory Commission.
So the NRC can certify a design. NuScale submitted and received a design certification for their 50 megawatt units. That is the only small modular reactor or advanced reactor that currently has NRC design certification.
Thank you. Mr. McIntyre, I just walked through with Mr. Capps the sequencing of construction of modular SMR units. Would you agree that offshore wind turbines are also modular assets?
Without a definition of what modular means in this context, I'm not sure I can make that assertion.
You can build them in stages. Is that true?
Yeah, I think it's true to say that we build virtually everything in stages.
So, okay. Yesterday, we mentioned South Fork Wind, the project off of New York. Are you familiar with that?
I am generally familiar with South Fork Wind.
They were able to build one turbine and let it start generating electricity and sending it to the grid before it completed its entire construction.
I think that is consistent with the model of constructing offshore wind facilities.
Right. So because they can be sequenced like that, would you agree that that is a definition of modular?
I don't know that I would call that modular. I would just call that sequencing, construction, and interconnection.
Okay. If I'll come back to that. Despite your disagreement with what modular means, you acknowledge that that is a common construction practice where you just build things in phases, correct?
I do.
And when you build things in phases, you gather learnings from units and turbines, like Mr. Cass described, correct?
I certainly think that it's possible to gather learnings.
So it's possible to learn from your experience driving that first monopile and interconnecting that first offshore wind turbine, and the second and third turbines in that system should improve in efficiencies through those learnings.
They can improve. I don't know that I would necessarily say they should improve.
Oh, they can. Fair enough. Would you agree that wind energy area leaseholders in this proceeding are already availed of some of these learnings, having experience developing offshore wind elsewhere across the eastern seaboard?
I would.
And if there is this staggered or sequence approach to building an offshore wind, could that potentially provide some earlier emission reduction benefits?
I would say that's an accurate assumption.
And as we will get into, being able to sequence construction like that on the configuration of turbines and offshore transmission plan and design, those potential configurations, we will not learn until wind energy area leaseholders can complete their construction and operating plan, correct?
I'm going to have to ask you to repeat that question.
Okay. The construction and operating plan requires, I'm going to flag that and I'm going to walk you through an exhibit because I think that would help. Mr. McIntyre, can you please flip to NCSEA Potential Cross Exhibits Volume 1, Tab 30? And while you're getting there, Presiding Commissioner Kemmerer, I would like to request NCSEA Potential Cross Exhibit 30 marked as NCSEA Cross Long Lead and Pumped Hydro Storage Panel Direct Exhibit 2.
It will be so marked.
Thank you.
I am at Exhibit 30.
Thank you. Mr. McIntyre, can you confirm that this document is from the Department of Interior's Office of Renewable Energy Programs and Bureau of Ocean Energy Management?
I can.
And it is titled Information Guidelines for a Renewable Energy Construction and Operating Plans, version 4.
Dated May 27th, 2020?
Yes.
Yeah, I'm there.
Thank you. Can you go to the top page 6, please? I believe I flagged it with an orange flag to help you out.
You sure did. Thank you for that.
It reads, the purpose of the COP is to provide a description of all proposed activities and planned facilities that you intend to construct and use for a project under a commercial lease, correct?
Yes.
On that same page, in the second paragraph, it reads that the data gathered from site assessment and site characterization activities should be used to develop your construction and operating plan, correct?
Correct. It does say that.
Thank you. Can you please now flip to page 8? There you will see section 5 is titled Required Survey Results and Supporting Data. Do you see that?
I do.
Thank you. And if you flip through the next several pages, I'm going to walk you through them. You'll see listed the required surveys for a construction and operating plan. So on page 9, do you see shallow hazard survey and geophysical survey data relevant to the design and siting of your facility?
I do.
On page 10, do you see A3 biological survey and A4 geotechnical investigation?
I do.
And A5 archaeological resources survey also on page 10.
Yep.
And then if you flip to page 11, A6 is the overall site investigation report.
I see it.
And that overall site investigation report is to incorporate all prior surveys that we just walked through.
Okay.
Thanks. So the last thing I would like to direct you to in this exhibit is now on page 12. I am going to read from you. I'm sorry, Ms. McIntyre, could you flip to page 12?
I'm looking at
Oh,
it
gotcha.
right now.
I'm going to read to you row B3 of the construction and operating concept under the guideline column. It reads, include, sorry. It reads that the guideline includes a discussion of the following using tables as appropriate. A description of the proposed activities, which should include is a description of the construction procedure for installing equipment, a description of how the project will be configured and how it will operate, including a description of the turbine array, any electrical service platforms, the subsea power transmission cables, and any shoreside support infrastructure, and C, any other relevant information. Did I read that correctly?
You did.
Thank you. So going back to our last question now, seeing that the COP is needed, and that is where we will learn the configurations and the designs of the projects, would you now agree that we will not be able to know the sequence of construction that until a wind energy area receives its construction and operating plan?
I would say that's accurate.
Okay, thank you. And Mr. McIntyre, having read through these selected excerpts, that many of these required surveys are viable early development activities common to all energy wind areas in North Carolina?
I can't represent if they're common to all wind energy areas. I mean, there are activities that would be common in and of themselves, but the results would probably not be common.
Right, but all wind energy areas need a construction and operating plan.
They do.
So therefore, it is common across all wind energy areas.
That requirement is common, yes.
Thank you. Understanding the results of the surveys conducted in those COPs will have different results, but the processes that they must undertake and the surveys they must undertake are in fact common.
I would agree with that, yes.
Thank you. And walking through these excerpts and reading the table from page 12, we now know that these surveys and early development activities for offshore wind are required to produce a detailed project specific to provide, excuse me. And would you agree that these surveys and early development activities are required to produce detailed project specific information for a offshore wind project?
Among other things, yes.
Yes. And more detailed project information, like the number of wind turbine generators, their configuration, and the length of the subsea transmission cable needed, will lead to more accurate cost estimates, correct?
I am not a wind energy developer, but I presume that the more information you have and the better information you have, the better your cost estimates.
Thank you. I accept your presumption. And likely because the construction and operation plan needs to be approved by a federal agency, some of those cost estimates may be more binding on the wind energy area, correct?
I'm not necessarily sure I would agree with that. I don't know that the Department of Interior and the Bureau of Ocean Energy Management binds developers to estimates of cost. I can't represent that they do.
Maybe the costs aren't bound by those agencies specifically, but the project plans that they will need to have approved by those agencies cannot deviate significantly without having to go back and revise, correct?
I can't represent the extent to which BOEM or any other agency requires developers to resubmit information as it changes.
Okay. So moving on, Mr. McIntyre. Would you agree that in the near-term actions plan, the companies are seeking authorization to incur costs for early development activities for other long lead resources?
Yes,
And would you agree that those early development activities for other long lead resources generally fall into the category of site assessment and site characterization?
I would say that's true, certainly of new nuclear.
Yeah, thank you. Mr. Capps, he anticipated my next question. If you still have Appendix J open, can you go to page 16, please?
Yes, sir, I'm there.
Thank you. And the second full paragraph on page 16 reads, another way for Duke Energy to mitigate risk from regulatory perspective is to obtain an early site permit. An early site permit allows the resolution of environmental and site safety issues, including seismic, geologic, and hydrologic, etc., for a chosen site, and can be completed early in the process before technology is selected or a decision to be built is made.
That's correct.
Thank you. And just to reiterate, the company's position is that these early site permit activities for new advanced nuclear reactors can be completed early in the process and before they decide to actually build the units, correct?
Yes, sir, that is correct.
And that is what the $365 million of additional funding that companies are seeking to authorize is for, correct?
No, sir, that is not correct. A portion of the $365 million, actually, proportionally, a fairly small portion is for the early site permit process for the first site and then to get started on the second site.
Okay, so a portion of the monies that the companies are seeking to incur are designated for these early development activities then.
That's correct.
Okay, thank you. I would like to point to another example. Mr. McIntyre, can you please turn to the Carolinas Resource Plan Appendix I? That is the renewables appendix.
I think I'm there.
Thank you. And Ms. McIntyre, page 18 discusses onshore wind, correct?
It does.
And we agree that this is the long lead panel, and onshore wind is not classified as a long lead resource per the company's carbon plan and various testimonies.
I think that's an accurate characterization.
Okay, thank you. So for illustrative purposes, can we please review the second sentence and the second full paragraph on page 18, which lists critical development activities to execute developing onshore wind.
I've seen that.
Okay. And at the very bottom of page 18, it reads, many critical development activities would need to be pursued in parallel with the target of completing all permitting and agency approvals by year-end 2028, such that construction could start in early 2029 and commercial operation would be achieved by year-end 2030, correct?
I see that.
And per page 20 of Appendix I, I'm looking at table I-4. The company is seeking authorization for approximately $65 million of development costs for onshore wind in this proceeding, correct?
That's correct.
So to summarize, the near-term action plans, the companies are seeking authorization for early development activities for other long lead resources.
Well, I mean, you correctly identified onshore wind is not a long lead resource, but I would say generally, yes, we are asking for development dollars for resource development.
Thank you. And many of those early development activities for long lead resources and onshore wind fall into the category of site assessment and site characterization.
I would say that's accurate.
And the companies did not seek authorization for early development activities relating to the site assessment and site characterization for offshore wind.
That is correct.
And the companies just sought permission for the ARFI.
That is correct.
Thank you. Moving on to the supplemental planning analysis. Ms. McIntyre, can you please flip to page 48?
I believe I'm there.
Thank you. I am looking at the continuation of table SPA 41. And do you see one of the very bottom rows is for offshore wind?
I do.
And then there is a note 6 next to offshore wind. It's like a footnote, superscript.
I see that.
Thank you. And I will read it because I transposed it and it is very small font on the printed version. Note 6 reads, the companies note that with any long lead time resource that results in a large multi-year construction project, the recovery of the company's financing costs during the construction period is important to ensure strong credit ratings to facilitate the lowest possible financing costs for customers. In addition, recovery of financing costs during construction lowers the overall costs that customers pay over the life of the investment. When financing costs are recovered during the construction period, non-financing project costs are still included in the customer rates only after the related project is in operation and providing service to customers, unless otherwise determined by the commission. Did I read that correctly?
You did.
Does the principle of recovery of financing costs during construction lowers the overall costs that customers pay over the life of the investment? Is that applicable to early development costs?
I can't represent whether it is or it is not.
Okay. Mr. McIntyre, I have one last set of questions, and it relates to something Mr. Capps said yesterday. Mr. Capps yesterday, in determining how to be a second mover in the deployment of a first-of-a-kind resource, and I'm paraphrasing, Mr. Capps said, you want to wait long enough to be number 3, but you don't want to wait so long that you're number 30. Do you recall that? Subject to check.
Subject to check.
Mr. McIntyre, despite all the hardships you elevated in response to the questions yesterday for offshore wind, given the pace and number of projects still moving forward along the East Coast, if Duke continues to take a cautious approach and not seek specific material actions for early developments on offshore wind, is Duke more likely to be number 3 in the queue or number 30?
I can't represent where in the queue the company would be, but I think it's important to clarify that, as I've noted, the companies do not currently hold a wind energy area lease. We do not hold a lease that is developable. And if I can take some liberties with the previous questions, there seems to be a suggestion that the companies ought to be requesting development dollars for offshore wind. That leads me to essentially 2 choices, the company's 2 choices. One choice is we choose, without direction from this commission, a wind energy area to begin development of, to the exclusion of the other 2, without having collected all of the necessary information that we need to determine what project is the most prudent project to pursue. Alternatively, we could pursue development dollars for all 3 wind energy areas and work on early site development for all 3, again, without direction from this commission, which I also do not believe is a prudent course of action. So consistent with our SPA, consistent with the NTAP, consistent with the stipulation, we believe that pursuing the ARFI is the most appropriate risk-based, measured, risk-informed process that will deliver the level of information that this commission needs to assert the extent to which offshore wind ought to or ought not to play a part in the diverse energy portfolio moving forward.
Thank you, Mr. McIntyre. But at the conclusion of the ARFI process, once we collect the additional relevant data, it is not the company's expectation that a procurement will occur.
We cannot opine at this time what the outcome of the ARFI will be. It has not been constructed. It has not been issued. So it would be premature to assume that the ARFI is going to result in any particular outcome.
And even though there is activities and information that seek to be collected in the ARFI, there are other actions that we just walked through that could also identify more price certainty for the ultimate resource.
I think there are certainly early actions that could be taken by the development community to understand the prices associated with their projects over the long term.
And if the development community had a clear path to market, being that Duke is the likely off-taker right now, would it benefit ratepayers to start incurring some of those costs earlier so that they are not adjusted for future risks of inflation and subject to other macroeconomic activities? It gives the ratepayers more certainty if these early development activities begin as well, correct?
I'm not sure that I would agree with that. I think that what we have done both in the NTAP, the supplemental planning analysis, and in the stipulation, I think what we've done is laid out a course of action that we believe is in the best interest of customers. It will involve the collection of a level of information that was not received during the original RFI. We will gain a better understanding on project structuring, preferences on project procurement, risk sharing, and things of that nature, the outcome of which could be an RFP, it could be something else. But we believe that the process that we've laid out provides a timeline that is consistent with the potential for the first tranche of offshore wind to be available by 2033. So again, as I've noted, we believe that this ARFI process is measured, it's prudent, and it's in the best interest of customers.
I think I'm just going to go ahead and do this. Mr. McIntyre, can you please flip to NCSA Potential Cross Exhibits Volume 2 at tab 77?
What was that tab again?
77. And Presiding Commissioner Kemmerer, as the witness, finds the potential cross NCSA requests to mark NCSEA Potential Cross Exhibit 77 as NCSEA Cross Long Lead and Pumped Hydro Storage Panel Exhibit.
Great. It'll be 3, I believe.
Three.
Okay.
Thanks.
It'll be so marked.
I believe I'm at 77.
Thank you, Mr. McIntyre. Thank you, Mr. McIntyre. Would you agree that this is the final order in the Virginia State Corporation Commission proceeding PUR 2021-00142, the application for approval and certification of the CVOW project?
That's what it appears to be, yes.
Thank you. And can you go to page 7?
I am there.
Page 7 identifies some of the risks contemplated by the Virginia State Corporation Commission. And the second bullet reads, Siemens Gamesa, turbine supplier for the project, has been hit hard by the supply chain disruptions. This is further complicated by the fact that there are 2 installations ahead of the project that will be receiving the same turbine design. Going back to my question about whether you are 3rd or 30th, in 2022, when this order was issued, the CVOW and the Virginia State Corporation Commission believed that CVOW was 3rd in line. Correct?
Subject to check.
So there's 2 installations ahead of CVOW, and CVOW would be 3rd if those are the only 2 installations. Correct?
If those are the only 2 installations, that's correct.
Thank you. And since CVOW has begun, since this order, CVOW has begun construction, so it is now in the construction phase and is no longer in queue, it is developing. But there are ongoing procurements in other states across the Eastern Seaboard, and more wind energy areas are being leased currently, correct?
There certainly are wind energy areas that are available for lease, yes.
Correct. And until there are significant Jones Act compliant vessels being built and other subsea cable wires being built, it is prudent for developers to get in queue to reserve their space so that when their turn comes, they'll be ready to go, correct?
I think that's an appropriate assumption.
So without taking affirmative action to get in that queue and send the appropriate market signals to developers, isn't that leading to delay that could create an execution risk?
I don't think it's fair to assume that delay is imminent and that execution risks are created. I think, as we've noted yesterday during my testimony, the offshore wind development market in North America is growing. We acknowledge that. I think we can all agree on that. The supply chain has struggled. There were some challenges that the sector saw in the latter part of 2023. We've seen some measured improvement in the supply chain in the first part of this year. I think it is appropriate to say that as this resource, in terms of construction, ramps up, it stands to reason the supply chain will continue to improve. So I don't know that I would characterize, first of all, the ARFI process as we've laid out as a delay. And in fact, I believe that the stipulation accelerates the issuance and the consideration of that ARFI for the intent purpose of providing this commission with the level of information it needs to determine whether or not offshore wind is going to play an imminent role in North Carolina's energy transition. If the ARFI results in this commission's directive to issue an RFP, we will do so. And that RFP will essentially be a binding effort with the development community in search of a developable wind energy area and ultimately a wind energy project. So one of the advantages, as I noted yesterday, of a measured approach is it allows for the continued development of the supply chain. And so, consistent with this process, I believe that the ARFI timeline allows for both the accelerated consideration of the resource, but also the build out to a certain extent of what we've considered to be a nascent supply chain today.
Thank you. I will reserve my questions on the stipulation for that panel, and the rest of the questions I had, I will revisit on rebuttal. So no further questions. Thank you.
Thank you. And that takes us to the end of cross-examination questions. So redirect from Duke.
No redirect.
Okay. So that takes us to commission questions. Commissioner McKissick, do you have questions? Okay. Okay. Commissioner Duffley.
So my questions will be for you, Mr. Capps. I'm going to wait on some of my questions for the rebuttal testimony, but I did want to talk about, did you hear my questioning of Witness Bowman?
I did not hear the questioning, but I have talked to Kendall, so I'm aware.
Okay. So I had mentioned to Witness Bowman about wanting to talk with you about the AP 1000, because we hear from leaders within Department of Energy an encouragement to build AP 1000s as well as small modular reactors and advanced reactors. And I heard the questioning from NCSEA about how the AP 1000 was not selected. It was not a selectable resource. But I did want to talk to you about the Harris plant. And can you remind me, when the Harris plant was first built, how many reactors were scheduled to be built on that land?
Yes, ma'am. When the construction originally started, the original intent was to build 4 units at the Harris plant.
Okay, and so, and obviously only 1 unit has been built on the plant
Yes, ma'am.
site. So, but can you tell me about the construction of the site? Is it built to house another 3 units at this point or not?
It certainly has. It certainly has the property, the footprint to support building additional units. You referenced the AP 1000s. we had actually started down the path of licensing the Harris site for AP1000s. We're not complete and stopped it some number of years ago, 5 or 6 years ago. So from a site perspective, it would certainly accommodate that. The one caveat is it would take to add additional large light water reactors at Harris would take additional water. And there was previously, when they were originally developing the site, there was a plan to do that with water from the Cape Fear River. So there is a way to accommodate that.
Okay, and internally, I mean, have you had discussions outside of the modeling with respect to your new nuclear development between looking at AP1000s as well as small modular and ARs? And kind of, can you talk a little bit about that?
Yes, ma'am. We have, and I think certainly finishing Vogtle and the Vogtle units coming online kind of change the perspective in a more favorable way that folks had for the AP1000s. We still have the license at W.S. Lee for 2 AP1000 units. So, and we have maintained that license. And as we go through the new nuclear development discussion, and we did particularly our site review, we have considered whether the sites we evaluated would be suitable for AP1000s based on the footprint, the amount of water. So it is something that we have continued to look at. My personal view would be over time, it won't be an SMR, advanced reactors, or AP1000s. I think it'll be an and. I think it'll be SMRs and advanced reactors and potentially and more AP1000s.
Okay, thank you for that. It's still a question for Mr. Capps, but Mr. McIntyre was talking about offshore wind, and he talked about the ARFI and the RFP, and he stated the RFP, the method of procurement has already been decided, and that the method of procurement for offshore wind has not yet been decided. And he mentioned the build, own, transfer in working with vendors. It made me think to ask you about how is the company working with the current vendors? As I understand it, you're looking at 4 different designs right now. And could you just kind of talk through how you're working with those vendors? Or are y'all discussing different methods of procurement with those vendors as well?
I think generally the discussions on the procurement methods for nuclear are EPC, the engineering, the procurement, and the construction. We've had multiple meetings with each company, and when I say meetings, not an hour, but a week, detailed discussions. The reactor vendors generally have construction partners, some more tightly held than others, but so we have talked collectively with them, but it's in an EPC vein in terms of how you would move forward.
Okay, thank you.
With any of them.
Okay, thank you for that. And then we also heard you speak about Clinch River, and it has an early site permit, correct?
Yes, ma'am, it does.
Okay, and what is do you know the current status of the Clinch River site?
So they have their early site permit, which is, if I remember correctly, they're good for 20 years. And TVA is currently working with GE to develop a construction permit application for the Clinch River site for a GE BWR 300X, a small boiling water reactor. The last thing I heard, they intended to submit that construction permit application by year end 2024.
Okay, thank you. And then you also mentioned the Darlington site, for Ontario Power.
Yes, ma'am.
So regardless of what design the company picks, are you planning on sending personnel to these different sites? We also heard about the advanced reactor site. So is that something that the company's thinking about during key installations, sending personnel to those different sites for learnings?
Yes, ma'am, we absolutely would. And we've had a lot of interactions with both of the ones you mentioned previously or to date, to learn what they're doing and what we can learn, what concerns they have, so that we can understand that for where we are in the process. So we have already been engaged with them and would certainly expect to continue to.
Thank you. And then I was going to save this for rebuttal, but I think I am going to ask it now, is with respect to the announcement, the DOE announcement that you mentioned for the 900 million.
Yes, ma'am.
Could you just talk through that for me?
Yes, ma'am. So the DOE recently announced a notice of intent to provide $900 million of funding, or to make it available for small modular reactor projects. I guess the most notable piece is they intend for $800 million to be available to two, they called them first mover teams. That's the terminology they picked, to try to accelerate deployment for two small modular reactors. And their vision for it is, I mean, essentially, folks will have to apply, kind of like the Advanced Reactor Demonstration Project. Groups of folks will have to apply to DOE, and then ultimately, DOE will select two that they'll fund. And when I say groups, ideally, what DOE would like would be to have a group of a utility, a reactor vendor, an end user, a constructor, it takes at least two of those to be considered a group, not necessarily all. But there's a meeting in mid-August for DOE to talk through the details of the program. We have been invited to that. We'll certainly participate in that. And then we would expect in the September or October timeframe for the request for proposals to actually go out on that for folks like us to provide input, to ask for one of the program funding grants. And it's a cost share. So, you know, if you think about it in terms of an SMR, there would be $400 million of DOE funding, and then whoever that receiving group is, the utility, the reactor designer, would collectively in kind also have to provide $400 million.
Okay, thank you for that. And I heard you say that you were going to attend the August meeting. Are you planning on, and I heard also in these groups, it could kind of be that full chain. Are you already speaking with other groups right now before that August meeting, or those other groups are invited to this meeting as well?
I think it would be both. We have already been speaking. I mean, we've had ongoing dialogue with all the reactor vendors. So yes, we would continue to do that. And then I think the intent is that sum of all those parties who are interested would be involved in this discussion in August.
Okay. And then moving on to the 100 million piece of that 900 million dollar announcement from DOE. Could you speak through that piece a little bit?
It's more, and can I clarify one thing, Commissioner?
Yes.
First mover, first of a kind, you know, there's a lot of different ways to draw that box depending on, you know, who you're talking to and how it gets framed up. For example, you could lump all the small modular reactors together and say, all right, who's first mover for that particular genre of plants? Or you can split it by reactor type and say, you know, who's first mover for a GE small BWR or a Westinghouse AP 300. So there's a, you know, there's a lot of different ways to take the first mover piece. But the second piece, the tier 2 piece is fast follower development. It's a smaller funding offer. It's $100 million. And it'll be similar in terms of, it'll be a, you know, there'll be an application process, but it would enable predominantly you to continue the advanced design and licensing and project development as a fast follower.
Okay. Thank you for that.
Yes, ma'am.
Okay, we've come to time for our morning break. So we are going to go off the record and come back at 11:15 in about 10 minutes. Go back on the record and we will continue with commission questions. Chair Mitchell.
Okay, just a few very quick ones. Mr. Capps, I think in your or the questions from Commissioner Duffley that you addressed, you discussed sort of work that the company has previously done with respect to licensing additional AP 1000 units. The company worked extensively towards an AP 1000 unit at the Lee site in South Carolina. Is that correct?
Yes, ma'am.
Okay, and y'all made significant progress towards certain early approvals that you would have to secure to develop an AP 1000. Is that correct?
We actually have an approved construction and operating license, an approved COL for the Lee site.
Okay. Company made the decision to cease work on that site several years ago. Is that correct?
Yes, ma'am.
Okay.
That's correct.
And that decision was presented to this commission in the context of a rate case, and the commission accepted that decision. Does that seem right to you?
Yes, ma'am, it does.
Okay. Is it your testimony or is it your opinion that the company could resume work at that site at some point in the future, taking advantage of the work that you all have already done there, if it becomes appropriate to do so?
Yes, ma'am, we could.
Okay. In your responses to one of council's questions, you indicated that with respect to nuclear, the trajectory of new nuclear units that might come online in the future, we are likely to see a mix of of AR, SMR, and perhaps the AP 1000. Did I understand your testimony correctly?
Yes, ma'am. And I wouldn't even limit it to AP 1000. Maybe it's just large light water reactors, of which AP 1000 is one.
Okay. I recently heard a presentation from a person who has technical credentials from France, discussing sort of France's approach to nuclear generation and the units that they have in service there. And there was a lot of technical detail given in that presentation that was sort of beyond my capabilities of understanding and sort of sorting through at the moment. But one of the things that stuck out to me was this concept of standardization. And he explained to us that they use the same type of technology, they use the same type of fuel, they manage they recycle fuel and they manage the spent fuel at each site sort of in a standardized way from site to site. Is there, to the extent that, there are going to be new nuclear facilities developed by the companies and sort of in this country in general, are there benefits to standardization? I mean, is that something that you all are focusing on?
Yes, ma'am, it is. And there are significant benefits. I mean, the piece we've been talking about is just the design, the construction, that aspect, but which is certainly true, right? Because not only do the lessons apply, but they'll apply directly to subsequent units. But beyond the construction piece, there are operating benefits to standardization. I mean, if you just think about inventory parts, it's, instead of having to have different parts for 5 or 6 different designs, you have one set of parts for one design. From a training standpoint, the training program for operators, for maintenance techs, chemists, it's all very similar and very consistent. So there's a notable benefit to standardization.
Okay. So again, to the extent that the company continues on the path towards the development of new nuclear generating facilities, do you foresee that the company will standardize its approach, or do you foresee the company pursuing different technologies? And I'm asking you to speculate, and I'm fine. I'm fine with that speculation.
And I wouldn't say there will only be one. I would never want to paint the picture that if we say it's 11,250 megawatts, it's only going to be resolved one way. But I think when we select an SMR vendor, a technology, I think our intent would be that is what we'll build for all the SMRs. If
Okay.
we select an advanced reactor technology, our intent would be that is what we'll build for advanced reactors.
Okay, all right, thank you for that explanation. I appreciate it. All right, Mr. McIntyre, one question for you. In your testimony, in response to questions from certain counsel for the interveners, you indicated that the company has entertained interest from large customers that or potential customers that would like to locate in the Carolinas that have sort of corporate goals related to carbon emission reductions. Is that, did I hear your testimony correctly?
You did?
To the extent that you're in a position to disclose, have any of those such customers made commitments to North Carolina?
I am not in a position to answer that. I think we have some economic development folks that will be providing testimony later in the case.
Okay, and
if-
I recognize that, but just and I just didn't want you to have to go into confidential information. But are you aware of, are there customers that you all are that have made the decision to locate here that have corporate goals related to carbon in the electric system?
I believe the answer to that question is generally yes.
Okay, so one of the objectives, if not the objective of this proceeding, is to determine the least cost path to compliance with the statutory requirements set forth in 62110.9. Is that correct?
Yes, I believe that's correct.
Okay. So to the extent that we have large manufacturing customers with very disparate goals, how does this commission go about reconciling sort of where that public interest lies?
I mean, that's an excellent question. I think the intent of this proceeding, as you noted, is to establish the least cost pathway to compliance. I believe that it's in the best interest of all North Carolina customers, whether they be manufacturing customers, residential customers. It's in their best interest to enjoy a resource mix moving out in the future that accomplishes those sort of three stools of affordability, reliability, and decarbonized over time. In terms of the actual process by which this commission would determine that mix, I believe that's what this proceeding is entirely focused on. I think you've heard from counsel from large customers. Obviously, energy price is something that's very important to manufacturing. It's an operational cost, and so it's in, I think, everyone's best interest in North Carolina to balance cost with the pace of decarbonization, such that we can continue to be an excellent top leading state to do business.
So how does the company specifically, with respect to this type of customer, that industrial customer, how does it go about sort of balancing or navigating competing demands that might even be like mutually exclusive?
I'm not convinced I'm the right person to answer that.
Okay, who is?
Perhaps our economic development team.
Okay.
I believe Andrew Tate is a witness in the proceeding, perhaps during rebuttal.
Okay, I will hold those questions for a different, and I might ask Ms. Bateman too. I'm confident she'll be able to answer it. Let's see. I think that is all. I think that's all I have at this point. Thank you.
Commissioner McKissick, and then I'll ask my questions after you.
And this is just a follow up on one of the things that Chair Mitchell mentioned in terms of a common design. This is my understanding right now. I think it's Ontario Power, TVA, and the energy company over in Poland, Synthos Green Energy, are already working on a common design for the GE Hitachi SMR. Are you familiar with that ongoing work that's being conducted at this time?
Yes, sir. I am. I mean, we have talked particularly with Ontario Power and with TVA.
Has there been any thought given to collaborating with them, since, I mean, you're looking at your various options to see if there might be benefit to I mean, they're already working on that common design concept. That would, obviously it would be just for that particular reactor, but it could be transferable information that might also be used with other reactors you might explore.
Yes, sir. I mean, there has been collaboration at some level, not the detail down to the, to the reactor design. We have certainly, as part of doing our due diligence and our vendor reviews, we have talked to TVA to understand, what they see as the predominant benefits and challenges with the GE BWRX 300 design, to inform ourselves if they see things that we have not. I think once we get to a technology selection, which will be in the near term, then were we to select the same one, I think at a much more detailed level, then we would certainly pursue that collaboration. And even if we pick a different design, we would continue to interact with both Ontario Power and TVA, because there will be very beneficial things we can learn about design, licensing, supply chain that'll be applicable no matter what vendor we pick.
Based upon information that you're aware of at this time, what are you seeing as the likely timeline for the Ontario Power project?
I think 2029 is still a reasonable time frame. They have started their pre-construction activities. They've started their licensing review with the CNSC, with the Canadian version of the NRC. And they've got a tremendous amount of support from the provincial government in Ontario to help them move forward. So I think 2029 is a reasonable time.
Reasonable time frame, a reasonable window.
Yes, sir.
And where do you see Duke moving? I mean, you're talking about 365 million right now. There's already the 75 million for the early site permitting. What do you see taking place, assuming the commission were to move down this path that you all have requested? What would be the timeline for getting things done, say with the additional 365 million that has been requested at this time?
And when you say things done, Commissioner McKissick, you mean to the point of physical construction, or?
Well, I'm assuming that's not going to get you to physical construction.
No, sir, it will
So
not.
I'm trying to understand where would it take you to?
Okay.
What would you be able to accomplish, and what time frame that would be accomplishable?
Yes, sir, I understand. So I guess the first thing to speak to is for the Blues Creek site that we're developing an early site permit for. That would get us through the submittal of the early site permit for the Blues Creek site. And then it would support the work we'll have to do, the NRC review fees, and then the work we'll have to do to support the review. So for that permitting process, when we submit the early site permit for Blues Creek, once we submit that early site permit, then we will immediately pivot and start working on a construction permit application for the Blues Creek site. So it would help fund that construction permit application for that site, which is the next step in the regulatory process to move forward. And then it would also, we would select a vendor, a technology, as you alluded to, and then there would be some amount of money that would go to them to fund the detailed design or pursuing the detailed design, and then we would also to be able to start construction in 2030, the long lead material, which is reactor vessel, steam generators, primary system piping, those kind of things, we would have to go ahead and secure contracts to start building the long lead time material. And then we would also start an early site permit on a second site
Second site.
to get us in that queue of having to work multiple ones to meet the needs.
And in terms of vendors selection, how many vendors are you actually exploring at this time?
From a small modular reactor standpoint,
Mm-hmm.
there are 4 that are to a point that we believe you can do a good, detailed, thorough review and have a perspective. And just relative to selection, there's an EPRI, Electric Power Research Institute document that kind of lays out a template for selection. And there are a number of categories that it has laid out and defined. And so that's kind of what we've used as a template to work our way through the selection.
Got it. Well, I mean, be curious to see how this all unfolds. And of course, the thing that I continue to hear about most is about where, Duke Energy would be in that timeline. I mean, it's come up before. It depends upon where you're number 3 or number 30 or how that timeline moves along. But the thing I also continue to hear about is about the need for some type of federal backstop to help guarantee cost overruns as it relates to particular projects that would be proposed. What are your thoughts as it relates to that and how it might impact the timeliness of Duke moving forward with the proposals that it is identified at this time?
Yes, sir. So I mean, we have been very engaged in discussions relative to the federal government and I mean, we'll use backstop insurance. I think that's an appropriate term. I mean, we've had a lot of meetings within the industry. We have collaborated with the industry and the Nuclear Energy Institute to come up with a consensus policy that the industry would support. And then we've had folks from Duke who've met with Senate subcommittees to talk about it. So I think there's general alignment and agreement that it would be beneficial, but we haven't gotten to a point to get it in legislation to get it out the door. So we have not gotten that level of alignment or progress with Congress at this point. But it is something that we continue to work on. And I think it's just risk mitigation. It's risk mitigation for you all, for the customers of North Carolina, for us as a company. So it would be beneficial to us, but likewise, it would be beneficial to others who choose to move early.
And if there was not legislation enacted that would accomplish that outcome or objective, how would you see it impacting the timeline that's been proposed for the SMRs that are currently being contemplated?
I do not think it would, Commissioner McKissick. I think the path we have laid out is the path we would continue to work at. But it would significantly help manage the financial risk.
Okay. Well, I think that kind of addresses concerns I had about what was being proposed, what was before us in terms of what would actually get done within the timelines that we're looking at this time. I do have some questions that I think would probably be most appropriately addressed when you come back for rebuttal dealing with the stipulation. I know it's come up, but rather than to interject those now, I think that I'd probably prefer waiting until that time, particularly if they dig into some of the wind issues. And I hope you guys will be coming back for rebuttal. Thank you.
Yes, sir. Thank you.
Okay, so I just have a couple of follow-up questions. Keeping on the subject of nuclear with Mr. Capps, In your testimony, your direct testimony, you talked about DEC's plans to switch for its existing nuclear fleet to the 24-month fueling cycles. Can you talk about whether that has already happened or what the time frame of that switching to a longer fueling cycle will be?
Yes, ma'am. So we have 3 of our sites that are already on 24-month fuel cycles.
Mhm.
Some of them have been for a long period. Brunswick, Robinson, and Oconee are on 24-month cycles. The information in the plan is to get Harris, Catawba, and McGuire to 24-month fuel cycles. And the just a little bit of background or a little bit of context, particularly for McGuire and Catawba. They're big plants, 1,200 megawatts. It's a lot of excess reactivity, and so when you start a cycle. So in order to extend the fuel cycles, you have to increase the enrichment. So there's a lot of analytical work and licensing work to support that. Certainly a path to do it, but it's a lot of work. The time frame is 2029, 2030, 2031. And the reason for that is the uprates that we're also pursuing for Catawba Unit 1 and McGuire Units 1 and 2. There is a fair bit of the analytical work, particularly the safety analysis work, that has to be done for both. So our intent is to do the two in parallel, such that we only do it one time, as opposed to doing it twice and having it cost twice as much incrementally as it would. So we have tried to pair up the uprates and the 24-month fuel cycles and do them together.
Okay. And can you just briefly explain the benefits that the extended fuel cycle will provide for the system?
So it essentially means less outage, right?
Mm-hmm.
So, I've tried to figure out how to walk through this. An easy way to think about it is in a 6-year period, if you just take the 3 sites, Catawba, McGuire, and Harris, the old way, each unit would have had 4 outages in 6 years. If we go to 24-month cycles, each unit will have 3 outages. If you just pick 25 days nominally for an outage, that's 125 less outage days for a large nuclear unit, which is very, very beneficial. Some more practical aspects. When we have a lot of outages in a year, it taxes us. It's hard on the organization is stretched. We have to rely on more outside help. This particular year, this calendar year, we have 8 outages. We are not set up for 8 outages. We're going to have 8, and we're going to do a good job having them. But it taxes the organization. We share resources. We call it shared resources. We will take our craft resources from across the fleet and send them all to an outage site. I say all is an overstatement, but we will send a lot of our own internal, very capable, very qualified resources. And it increases the expertise and it decreases the amount of supplemental resources we have to bring in for an outage. So if we go to 24-month cycles across the fleet, we won't have 8 outage years. We'll have 1 year with 5 outages, 1 year with 6 outages. The other thing I would say, and we kind of touched on it yesterday, we try to end outages by the start of December. So if you take this fall as an example, we have 4 outages. If you get past the summer and you're in by the 1st of December, you got to fit 4 outages in 3 months. They don't fit. You end up with overlapping outages. And that causes us challenges from a resource standpoint to move our resources to the outages. And then it also causes challenges just from a system standpoint because you got multiple units shut down at a point in time. So I think there are a lot of benefits, some direct, some more indirect, but would certainly be beneficial to customers.
Thank you. That's very helpful. And I had a question. You talked about that the Duke's preference in regard to new nuclear that's been planned is to be a fast follower. And I think you also said that that you believe that you are a follower because you've learned lessons from other projects, and specifically the Vogtle reactors. And I don't want to go into a rabbit hole with this question, but if you said that there were lessons learned. Are there any specific lessons learned that you can share with the commission from Vogtle that would be applied to plans for new nuclear? I know that that's a complicated and complex question, but if there's just a summary that you could provide to the commission.
Yes, ma'am. At a high level, I would say one key piece is just the level of oversight and the level of intrusiveness that the utility has to establish and has to have for the EPC contractors to know what's happening, to know where the hard spots are. I mean, if you look at the first few years of the Vogtle project, it struggled. You know, they essentially stopped work. They brought the work in-house. The Southern Nuclear had a whole different level of engagement with it. They brought Bechtel on as a partner, and things were much more predictable after that. So I think that's one key piece. It can't be that we contracted it, so whoever the vendor is, you go build it and tell us when you're done. There's got to be a level of intrusiveness and a level of engagement from day one to the last day. That's a key part. And then we talked about one of the big benefits of Vogtle and of small modular reactors being the modular design. Well, it only helps if you have the modules when you need them. And they had challenges with quality and predictability getting modules. And it ultimately impacted the schedule. And so that was another piece of work that at a point in time they brought in-house and essentially farmed out to multiple fabricators and got better production and better predictability with that. So that would be the other key. And the piece to think about, and I don't know exact numbers, but you get into construction and you end up with 2,000, 3,000, 4,000 people on site. You need a something, and you have to wait a month to get the something to move the critical path forward. You've spent a lot of money with resources that may not be idle, but they're not moving the critical path forward. So that's the piece you got to.
Thank you. And then, Mr. McIntyre, one question. I want to make sure I understood your testimony yesterday. I believe it was from cross-examination from Mr. Smith. And you were talking about the offshore wind RFI, and you stated that the RFI did not decide how to procure the wind energy area, and whether it would be a sale of the lease or a build-own transfer. And what I thought I heard you say, and I want to get clarification because I may have misunderstood, is I recall that you said that the developers did not provide information about what they preferred, or there was no consensus. Did I hear you correctly? And if so, can you provide a little bit more information?
I'm happy to try to clarify. I can't give you the level of resolution at this time, what any particular developer represented as it relates to procurement, but I am aware that I believe in at least one case, we did not receive information on the preferred method of procurement, and in other cases, they were not consistent. So that seems to be an outstanding question that needs resolution.
Okay, thank you very much. Commissioner Tucker?
Thank you, Commissioner. My questions, being new, will be from the 50,000 foot level. First of all, I guess, Mr. McIntyre, I think in the supplemental plan in January and the one that was filed, I guess, in August of 23 for us, It targeted a wind date to bring a resource online by 2032. Is that correct?
I believe the original filing in August did target 2032.
Okay, and did I understand you to say that as it related to Dominion and Virginia Power and Light, legislation, et cetera, that they started the process in 2013?
I would say that Dominion has been at this since 2013. They acquired their lease from the Bureau of Ocean Energy Management in 2013. I believe the legislation, the Virginia Clean Economy Act, wasn't passed until 2020, if subject to check, if memory serves. So they've had their legislation a little bit longer than we have. They've been at CVOW, if you include the time between the acquisition of the lease and the legislation since 2013.
So the spread in time, 11 years versus 7 with the 2032 date, do you still maintain that that's your target date and that it's achievable without the head start that they had versus us?
So it's a great question. I believe in the supplemental planning analysis, we adjusted that 2032 date to 2033. And I believe, subject to confirmation from our transmission panel, that shift had as much to do with onshore transmission system upgrades as anything. The situation between Virginia and the Carolinas is somewhat different. In the case of CVOW and Dominion, they enjoy a pretty significant load center right there in the Tidewater area, Virginia Beach, Norfolk, Hampton Roads. In the case of North Carolina, we don't have the same sort of scale of load center on the coast. So a lot of the work that's going to need to be done for a North Carolina offshore wind facility involves onshore system network upgrades. We're in the midst of considering those upgrades now. Again, I would defer to our transmission panel for specifics on that. But we believe that if we can execute the ARFI consistent with the stipulation, and coming out of that, if offshore wind is a selected resource, then we believe that the first tranche of that resource could be available by 2033.
Okay. All right. Thanks, sir. The other question, I was in a briefing early when I came on in December with Dominion building a ship to be able to, I guess, drill, I don't know what the word would be, on the ocean floor.
Yeah, wind energy installation vessel, I think is
Right.
the industry jargon.
Yeah. It was over budget, $200 million, and it was delayed on, well, maybe I'm incorrect on that, but the time was delayed, and at that time, I understood from them, if I recall correctly, it was like only one ship that could do that in the world. Is their ship operable now to be able to be leased? I think the lease cost they mentioned to me was like $350,000 a day for that one ship that comes from Europe.
So I think we can unpack that just a little bit. So you're correct. Dominion did make the decision to commission the construction of the Charybdis. It's the name of their wind energy installation vessel.
That's right.
It's was manufactured at a shipyard in Texas.
Brownville, yeah.
I don't have the specifics, but I do think that it was over budget by some number, and it took a little bit longer to manufacture than originally intended. My understanding is that vessel is currently in service, but it is the only Jones Act compliant wind energy installation vessel in North America. And so the number that you referenced, the $350,000 a day, I think was comparing if you had to lease a ship to do essentially what Dominion's Charybdis is going to be doing, you would be paying a premium because on the global scale, I believe there are only a few dozen such vessels that are available. And again, only one in North America.
Okay, thank you, sir. I have been recruited by Commissioner Duffley to serve on a nuclear subcommittee, Mr. Capps, in NARUC. She is well versed in nuclear technology and is somewhat mentoring me. And so my questions have been discussed with her to some extent. So there will be 50,000-foot questions as well. Getting to SMRs, I know you do a substantial amount of light reading about nuclear on the weekends, I'm sure. And do you know anything about TerraPower in Wyoming?
Yes, sir, I do.
Okay, and do you know about the Kimmerite Wyoming, excuse me, correction, Kimmerer for you, ma'am, for the record, it is spelled Kemmerer. That's how I got it confused with Kimmerite, Wyoming. But at any rate, that they're building a 345 megawatt cooled liquid sodium reactor that's supposed to come online in 2028. I've heard you don't want to be first, or you're going to be 30th from the Intervenor Council, and they're trying to get you to move somewhere in the line where you were going to fall. That project, would that ramp up the ability to be able to have the proper testing of materials, et cetera, that the Idaho lab's going through now? Would that move the SMR availability up any?
So a couple things. I think the date that the TerraPower Natrium plant is currently working to in Kimmerer is 2030 for an online date. And it is a bit different than the small modular reactors we're considering or are about to make a choice on at this time, because it is liquid sodium cooled as opposed to water cooled. But it will provide benefit in the context. They have to go through a similar process, right? So they'll have to go through the licensing process. They're working right now. They have just submitted their construction permit application, which will be the next phase for us after the early site permit at Blues Creek. So there will certainly be things that we can learn from that. And then, just the challenges they'll go through with design, with licensing, with supply chain. We'll be able to learn things from that as well. And we actually have 3 individuals from Duke who are supporting TerraPower in their efforts in Kimmerer, Wyoming. So we've kind of got a front row seat to the things they're working through and the things that they're dealing with. Our folks, they've predominantly used them because of their operational knowledge. Our folks are all folks who have grown up in our operating plants and operations, engineering, work management, training. So they've got a broad operating knowledge. And so that's what TerraPower has tried to draw on to help them. But just by virtue of being a part of that process, we have garnered a lot about what it takes to work through bringing a new plant to bear.
Okay, the cool liquid sodium, that's a problem with hydrogen and the opportunity to be flammable and volatile, which is totally different from what you're doing or going to plan to do with water cool, right?
Yes, sir. It is. I mean, liquid sodium's challenge is if it's exposed to air or water.
Right.
It reacts badly. It burns.
Okay.
Its benefit is it's got phenomenal heat transfer properties. So you can operate a reactor at 1,000, 1,100 degrees, use liquid sodium for a coolant, and operate it at atmospheric pressure. So
okay.
I mean, it's like anything else. There's good and bad to it, and to be successful, you have to learn to manage the things that are the downside.
Yeah, that reactor is going to replace 250 jobs. They're shutting down a coal plant.
Yes,
of course, coal's big in Wyoming. It was cited by the interveners in response to you that there's really no SMRs that are active supply and generation in the U.S., but they are over the world. There's tons of them. As I read, China and Russia have had them.
Yep.
Mitsubishi's developed, let me think what, the SRZ 1200, which they have developed and used their catastrophe with that nuclear plant over there, and have learned responses to that as they develop that. What do you think the cost of, and I know, I don't mean to get into hypothetical, but I read that probably SMR would be somewhere in the neighborhood of $1 billion. Would that be something you agree to, or you just subject to check, or don't respond, it's fine?
So I think we'll have a lot clearer picture on cost once we actually pick a technology and dig into the details with the vendors. To date, we've relied on an Idaho National Labs report to come up with cost, and it took a lot of different projects and assimilated them and tried to look at them in aggregate and come up with what would the cost be. I think, if hypothetically, or my opinion would be, $1 billion is probably low.
Low.
Yes, sir.
Okay.
For a 300 megawatt SMR.
Okay. Well, thank you. That's all the questions I have. I commend you on your weekend reading as well.
Yes, thank you.
Commissioner Deftly.
So commissioners ask questions, and then it reminds me of questions. One of the questions that I meant to ask was with respect to to Mr. Capps, the domestic supply chain. If you could just speak to the developments of the domestic supply chain in the U.S.
The big challenge with domestic supply chain are the large components. You know, the things like we referenced earlier, the reactor vessels, the steam generators. The majority of the shops to do things on that scale currently are you know, in South Korea, Japan, or Europe. Canada actually has a facility that could do it as well. Beyond those large components, the large forgings, then I think the supply chain in America will grow to support the needs of the industry. The large stuff is where the challenge would be.
And can you speak to the fuel supply chain as well, please?
From a fuel standpoint, the real challenge is with the plants that need high, say, low enriched uranium. So enrichment above 5, 6, 7%. You know, for the low enriched, similar to what we run today, all the small modular reactors we're considering use fuel just like we use in our plants today. Now, I mean, so I don't foresee a challenge with those from a supply chain standpoint. Obviously, the industry will have to ramp up, right? Both in terms of the mining for the uranium ore and then the conversion and enrichment to get us to a point to fab it into fuel. So there will definitely have to be an increase in supply, but I think the industry can respond to that. The bigger challenge is with the plants that use the high, they call it HALEU, but the higher enrichment fuel, and coming up with the process and the capacity to enrich at that level.
Okay, thank you. But the Piketon plant obviously is the first HALEU fabricator in the U.S. and
Yes, ma'am.
they're currently in operation. Is that correct?
Yes, ma'am.
And then my second question, I was going to wait and ask this on rebuttal, but I think there was some discussion about it. So I'm going to go ahead for the record and refer to your rebuttal testimony. You don't need to turn to it. On page 14, you talk about, you say, for example, if federal support for early movers and fast followers were made available that included construction costs, overrun insurance or grant program was put in place that provided a cost share, this would help mitigate some of the risk of being a first of a kind or fast follower project. And I wanted to focus on this cost overrun insurance. And I heard you, in responding to a question, talked about how, did you say that Duke representatives had gone to speak to certain Senate offices?
Yes, ma'am, we have.
Could you further expand on that testimony, please?
I I know there was a meeting last year that our executive over generation, Preston Gillespie, sat in on with the Senate Intelligence Committee, and they invited 4 or 5 people from the industry to have a discussion on, you know, what it would take to further move the industry forward. And then I mean, there've been subsequent discussions with our government affairs folks and the folks in Congress.
Okay, and I believe I heard you state there's no pending legislation. Is that correct?
Yes, ma'am, that is correct.
Okay, do you know if there's any, if you can answer, is there any draft legislation?
There was, my understanding is there was draft legislation, but it did not make it out of the committee.
Okay, thank you for that. No further questions.
Commissioner Hughes.
I want to thank you for the last half hour of nuclear education. It's been very enlightening for me, but it's made me think a little bit more about offshore wind and the amount of discussion that we've had and with some of the responses to the intervener questions about offshore wind. And I just want to clarify some things I heard about where Duke is now with offshore wind. So the money I think I heard you correctly say that you are, quote, bringing on some development assistance for offshore wind, or did I get that wrong?
I don't think I said that.
Okay. Okay.
We don't currently have a lease area to develop. So
I'm talking about like internal just expertise for the okay.
So I can't represent the extent to which our system operations and system optimization and planning organization has or has not hired offshore wind expertise.
Okay.
That's ostensibly where it would live because that's where our renewables development organization lives.
Okay, I apologize. I must have gotten it wrong. With that said, obviously the amount of expertise the three of you have and Duke has with nuclear is largely due to your past experience, but also it sounds like there's an enormous amount of research, I guess, or however you want to say it, going on now with nuclear. Could you just describe a little bit more about like what's going on with offshore wind in the same sort of vein of, you know, everything from embedding your staff in other projects to kind of tracking things?
Sure.
I mean, you don't have to go as long as you did for nuclear, but just what's happening behind the scenes.
Yeah, thank you, Commissioner. I appreciate that question. I think it's important to note that the nuclear industry in the United States has been around a long time, right? I can't represent, and I know Mr. Capps certainly can, when our last reactor came online, but we've certainly been operating reactors for 4 decades. And so there is a significant amount of experience specific to utility scale nuclear generation that we have developed internally, the industry has developed, and I think as Mr. Capps indicated, there's considerable collaboration among utilities and technology providers, vendors. On the offshore wind side, I believe Block Island was the first operational offshore wind facility in the United States, providing energy to Block Island in the manner of 5 offshore wind turbines. I can't represent precisely when that facility came online, but I believe it was in the 2018 timeframe, maybe. Obviously, Dominion has their 2 pilot turbines that they commissioned and have been garnering experience on. There are other projects that either have been commissioned or are currently under construction. So it's a relatively and comparatively young industry when you compare it to the nuclear industry. Certainly, we at the company, and I'm certain other utilities and developers communicate with each other on a routine basis. As was noted, I serve on the board of the Southeastern Wind Coalition, And so I am afforded the opportunity to engage in dialogue with folks from Total, from Dominion, and we do that on a, as I noted, a regular basis. So while the industry is considerably younger than the nuclear industry, we certainly are benefiting from the development of relationships sort of across that sector, so that we at our company and others can benefit from the learnings of others.
I appreciate that. Are you nervous based on what you've just said and the timeline for bringing on the offshore wind now versus the timeline for bringing on the nuclear? It just seems like you're in such different spots, but the timeline's not all that different.
Yeah, I mean, I think that's a fair statement. The timelines aren't that different. I believe that those timelines are largely representative of when we believe we're going to need resources to meet load. And so there's the need, obviously, to bring new generation resources online. I don't know that I would characterize my feeling as nervous, but certainly there's a long way to go as it relates to offshore wind before I believe we have turbines spinning off of our coast. We'll benefit from the learnings of others. We'll go through this ARFI process, assuming it's the will of the commission, and we'll learn a lot coming out of that that will inform the next steps. And you know, those next steps, as I've noted, we don't know what they are at this point, but one perhaps outcome of that ARFI is an RFP that would be binding and ultimately perhaps lead to a contractual agreement that provides definitive scale, pricing and timeframe. So I don't know that I'm nervous, but I think you are correct in noting that these timelines, I believe, are aggressive for all of our resources. And it's just a recognition that we live in a state that's popular and we have a significantly growing load, and we've got to meet that load.
No, I appreciate that. And I apologize for the comment about the development. It might have been the onshore wind that might be doing that. I think that I might have conflated that. So let's just assume, subject to check, that they are bringing on some internal resources. Was there a discussion about doing something similar for offshore wind?
I am not aware of any current discussions or past discussions. That's not to say they're not happening, but if they're happening outside of my responsibilities.
Okay, well, that's all for now. Thanks.
Chair Mitchell first. Commissioner McKissick.
Yeah, just to follow up on Commissioner Hughes' question. I mean, I gather that once, and I'm going to refer to it as the ARFI, that's kind of an acronym I'm accustomed to, is concluded. You're talking about, you know, an RFP coming forth from that. If you were to look at timing right now, how long, if we authorize this, what has been proposed, do you think it would take for the ARFI to actually go out there, gather the information, be in a position to provide greater insight, so there could be an RFP that would flow from that? But what's that window of time realistically looking like based upon where you stand today?
Yes, sir. Let's assume for the time being that the commission issues an order that directs the company to pursue the ARFI. And I apologize, I can't make myself use the expression ARFI.
I understand.
It sounds like a 1980s television show to me. And so
There's a good reason for that. I think there was one.
Just say ARFI. So
Okay.
I'm going to stick with ARFI.
Sure.
So let's assume that we come out of this proceeding with an order that adopts the stipulation and directs the company to work with the public staff and the development community to develop the ARFI. I believe the stipulation as it is currently contemplated directs a 90-day development timeframe. So upon issuance of an order, that ARFI would be issued within 90 days, and it's got to essentially be complete and a report delivered to this commission by July 30th of next year.
And of course, I believe there's also discussion of an independent evaluator
That's correct, sir. Yes.
being a part of this process.
Yes.
How do you see that interfacing in terms of looking at each and every one of those components?
So I would suspect that the process would very, very closely resemble the RFI that we conducted coming out of the original order. We have at our disposal today an IE in the form of DNV Energy that has experience conducting that sort of an effort. That's not to say that we have selected that organization to conduct an ARFI should we be directed to do so. But I think that the ARFI process would closely mirror what the RFI, the process of the RFI.
All right. And of course, it's also contemplated that potentially there'll be this asset acquisition price established.
That's right, a reference price. Yes, sir.
Now, theoretically, that asset acquisition price could be established at a point where some of what's being contemplated now might not necessarily be feasible. Do you see that as a possibility, or do you see it being informative of what the maximum price would be if you were to go down the path of, moving forward with offshore wind?
Yeah, I think that's a great question. So that concept of a reference price, my understanding is it would be essentially an outcome of the analysis that would be conducted by that IE after having gathered all of that additional information through the ARFI. So that reference price is essentially what I view to be kind of a ceiling, or a floor, maybe, above which it's probably not appropriate to proceed, below which we would then sort of opine on next steps from a development perspective. And as is stipulated in the settlement, we would have to explain why we would not pursue or would not initiate development should we decide not to if projects came in below that reference. So I think the reference price is an outcome of the work that would be done by that IE as part of that ARFI. Does that make sense?
It does. I mean, I was seeing it as a ceiling more than a floor.
Yeah, I probably used the wrong word, but
You know what I mean? A ceiling beyond which
Yes, sir.
it may not be
I think that's a better way
financially
to characterize it.
feasible
Yes.
as opposed to a floor.
And I'll interject here. I think that there'll be plenty of opportunity to talk about the details of the stipulation on rebuttal testimony. So we can delve deeply into that during rebuttal testimony.
Sure. That's not a problem. I was just trying to get some idea of how you viewed this all taking place, the timeline, what it realistically would look like based upon where you stand today. And I think you've provided some context in connection with it. I guess the only other question I would have is this. If you were to read intervener testimony, they talk about the need for contractual certainty
Yes, sir.
at the earliest possible point in time. And I believe Avangrid even talks about establishing some measures that they'd like us to take even before theoretically a carbon plan order would be entered. Could you provide your thoughts about where you stand in connection with what's been discussed and proposed?
Certainly. I can't necessarily speak for the developing community, but I can
Yes.
appreciate that an ARFI in and of itself is not a binding effort. We would, of course, working with the IE and the developers, endeavor to construct that process in such a way as to the extent we can, get as much binding information as possible. But contractual certainty to me is the outcome of an RFP process. So as we've noted, there are a variety of outcomes that could come out of that ARFI. One of them could be an RFP. And if it be the will of this commission that we pursue such a document, we could go that route and land in that sort of contractual certainty space, I think, reasonably quickly.
Thank you.
Okay, Chair Mitchell.
One question for the panel. Do I understand correctly that as things stand right now in this docket, the company's proposal is that you'd have a new nuclear unit, perhaps unit 1 in service by 2034 and another unit in service by 2035?
Yes, ma'am.
Okay. And then for the offshore wind, you're currently sort of anticipating in service of 2034, 35 timeframe?
I'm sorry, I spaced out there for a minute. Could you repeat that question?
Absolutely. companies projecting an in-service, potential in-service date for offshore wind, I'm sorry, of 2034, 2035.
I think the SPA contemplates the first tranche, 800 megawatts, being available 2033.
2033, okay.
Subsequent 800 megawatt tranches being available in the subsequent 2 years.
Okay, 2033. Okay, thank you for that correction. And then, Mr. Capps, well, for the panel, in terms of relative expense or capital levels of capital investment necessary, is it a fair assumption that the offshore wind and the nuclear facilities are the most expensive undertakings the company would be required to take on of the types of generating resources proposed in the carbon plan?
I don't believe I can answer that in an absolute sense in terms of having done a comparison of costs.
And I'm asking, and this is speculation, and I just want a very high level response. I know y'all aren't putting any hard numbers in front of us, and you probably haven't done it. You know, we're talking about estimates at this point in time. I understand all of those caveats, but just very general terms based on what we know right now, offshore wind and new nuclear would be the most expensive investments the company is contemplating making under this carbon plan.
Yes, ma'am. I think you would have to lump the Bad Creek piece as well. I think it would be these three.
Okay.
In aggregate.
Mr. Smith, do you agree with that?
I do.
Okay. Okay. And when is the Bad Creek investment? When would you have, assuming all goes according to Duke's plans for the Bad Creek 2, when would that additional capacity be placed in service?
That'd be 2034.
2034. So, 2034. Okay. Okay. That's all I needed. Thank you.
Okay, so we're going to move to questions. Oh, Commissioner Duffley has another question.
So I was going to ask this question, and it kind of follows on. I had come up with the question before Chair Mitchell asked her question. But so what I was originally going to ask is to the group is the timing glide path to development and execution. Is that the same between offshore wind and nuclear? We just heard the answer with respect to the execution dates. So from the execution dates, can I assume that the development timing for offshore wind is less than for nuclear? I just open up those timing glide paths to execution for both of these long lead resources.
Yeah, I'll let Mr. Capps speak to the glide path for nuclear. I believe it's safe to say that in the case of offshore wind, frequently much of the work is sort of on the front end. So there's a pretty substantial amount of time needed for site assessment and permitting, getting a record of decision on an environmental impact statement from the Department of Interior. But once you've got the green light to proceed, as we've seen with CVAL, they're able to execute construction between 2024 and 2026 on a 2,600 megawatt offshore wind facility. So maybe while the time frame in totality may be similar, I can't necessarily represent how the two resources compare to each other in terms of what you would be doing when.
Okay.
But I mean, and Commissioner Duffley, for comparison's sake, for nuclear, if we just use big round numbers, the first 6 years, if you look at the plan we've laid out, is permitting, licensing, and detailed design. And then there's long lead material. There's other things that'll have to happen in that window. And then the actual construction and startup testing is the 4 or 4.5 years on the end.
Okay, thank you both for that.
So I thought we were done with commission questions, but it raises one question, and this may not be the panel to answer it, but if you can let me know who could answer it. But in the event that either SMRs, new nuclear, or offshore wind does not come to fruition in the 2034, 2035 timeframe that we're talking about, what is the generation that would be proposed that would be replacement to either offshore or the SMRs? Is this a question for this panel, or which panel should I ask that question to?
That's a great question. I'm not precisely sure what the best panel is, but I think the way that House Bill 951 sort of imagines the carbon plan proceedings, it's that check and adjust notion, right? So we'll have the opportunity to come back before this commission as early as next year with additional thinking around resource planning and carbon planning. And so I think it would be premature to try to prognosticate what that replacement generation would be. But I believe this process is the appropriate process to sort of land on those conclusions.
Okay, thank you. So it's 12:30. We're going to go ahead and take 12:28, I should say. We're going to go ahead and take our lunch break before we ask questions on commission questions. I did want to give a caveat for questions on commission questions. We have delved, all of us here have delved pretty deeply into rebuttal testimony and details about the stipulation and the amended stipulation. I do want to give everyone an opportunity fairly to ask questions on commission questions, but if we can wait till rebuttal to ask questions about rebuttal testimony or the stipulation or amended stipulation, that would be my preference. So keep that in mind as you ask your questions. So with that, we'll go off the record and we'll come back at 1:30. On the record, we have finished commission questions, and now we're ready for questions on commission questions.
Good afternoon, gentlemen. Tyrrell Moore with the Attorney General's Office. I just have a couple questions, and I think they're all going to be for Mr. Capps. Commissioner Duffley asked you a question about Sharon Harris specifically and the potential to add an AP 1000 unit at that site. Do you recall that discussion?
Yes, sir, I do.
And you talked about how the company at one point had started looking into that potential. Is that correct?
Yes, sir, it is.
And just to clarify for the record, the company's actually filed an application with the Nuclear Regulatory Commission in 2008 to construct 2 of those units at that site.
Yes, sir, we did, and then we stopped it before it got through the review process.
And the companies are planning to pursue subsequent license renewals for the Sharon Harris Unit 1. Is that correct?
Yes, sir, it is.
There was another line of questioning from Chair Mitchell about cost savings from standardization. And I think as part of that discussion, you mentioned cost savings from had there being the same parts and the same training. Do you remember that discussion?
Yes, sir, I do.
And to your knowledge, have those cost savings been included in the cost estimates that you provided to the modeling team?
I could not say one way or the other. My initial thought would be we probably aren't far enough into the process to really know. I mean, the cost the modeling team used came from an Idaho National Labs study that was a kind of an aggregation of cost data from a number of different things over years across the industry. So that is the cost input today.
And Mr. Capps, can you be sure to speak directly into the microphone,
ma'am.
please?
I'm sorry.
Thank you.
And would there also be cost savings from siting additional units at an existing site?
In the sense that if you use an existing site, and when you say site, you mean nuclear site, retired coal?
Let's take Sharon Harris, for example. Would there be cost savings from putting additional units there versus at a greenfield site?
Yes and no. There would be cost savings in the sense that there is infrastructure you could take advantage of. But there would also be a cost to trying to build a reactor on the side of an operating reactor.
And that site was designed with the to host 4 reactors, is that right?
That's correct.
Is it your understanding that if you were to include the AP 1000 as a selectable resource in the model would be able to balance the cost savings due to standardization versus other cost savings provided by perhaps the AP 1000?
You would need to ask Glenn and Michael and those folks that question. I'm not a modeling guy.
All right, no further questions.
Ms. Chris.
Thank you. Gentlemen, you were asked a question by Chair Mitchell regarding whether there are customers that have made the decision to locate here that have corporate goals, excuse me, related to CO2 emissions reductions and how the companies are seeking to balance some of the competing priorities related to those CO2 emissions reduction goals. Do you recall that question or that line of questioning?
Yes.
Yes.
And do you agree, subject to check, that on May 29th, 2024, the companies announced memoranda of understanding between the companies Amazon, Google, Microsoft, and Nucor?
Yes. Yes.
And are you generally aware that the purpose of those memoranda is to directly support both the CO2 emissions reduction goals of those customers as well as the goals of the company's energy transition?
That's my general understanding, yes.
Thank you. Chair Mitchell also asked you a question about the relative expense and levels of CapEx necessary for the investments in offshore wind and nuclear. Do you recall that question?
Yes, it was a general question, just relative to, are those the largest?
That's right. Do you have Appendix E handy? If not, I have it as a SIGBR exhibit and would be happy to put it in front of you.
I do not.
Okay. We're going to have you turn to SIGFR potential redirect exhibit number 90. And presiding Commissioner Kimmerer, I would request that this be marked SIGFR 2 and 3, long lead generation and pump storage hydro, direct cross exhibit number 2.
And for the style, I will call it SIGFR 2 and 3 cross long lead generation and pump storage hydro direct exhibit 1.
Exhibit number 2, I believe.
Excuse me, exhibit number 2.
Yes, thank you. Gentlemen, is it fair to say that there are only 4 technologies listed on this chart of generic unit overnight technology capital costs that exceed $4,000 per kilowatt? Those being generic small modular reactors, generic advanced reactors with thermal storage, 8-hour lithium ion storage, and offshore wind?
That appears correct.
Thank you. No further questions.
Mr. Smith?
Yes, just a few. My first question comes from Commissioner Tucker's question on Dominion building the Jones Act compliant ship. Do you recall that question?
I do, yes, sir.
Are the companies proposing to build a Jones Act compliant ship to install offshore wind off the coast of North Carolina in this proceeding?
Not to my knowledge.
Are you aware of any plans the company has to build an offshore wind ship like the one Dominion had built?
I am not.
Okay. And then there was a question from Commissioner Hughes, juxtaposing the maturity of offshore wind development versus nuclear. And the answer went to some degree about how nuclear's been around for a while. Do you recall that question?
I
And that
do,
answer?
yes, sir.
Okay. Are you aware that offshore wind has been commercially available in Europe since 1991?
I am aware, yes.
Are you aware that by 2012, UK had over 3 gigawatts of operating offshore wind power?
Subject to check.
No further questions.
Okay, thank you. Justin Simulowski with the North Carolina Sustainable Energy Association. I will do my best to work through these quickly. Mr. Capps, Commissioner Duffy asked some questions about Harris Plant and if that site can be scaled up with 3 additional units, including an AP1000 under the site permit. Do you recall that?
I do.
And Harris Station is a pressurized water reactor, while an AP1000 is a light water reactor, correct?
Same basic thing.
Okay. On page 16 of Appendix J, can you turn there real quick?
Okay.
Thank you so much. There it reads in the second paragraph, I believe, the ESP that's currently being worked on right now includes an improved environmental impact statement, which provides finality on the environmental regulatory issues. And the company's approach to the ESP is to be tech neutral using a plant parameter envelope. Does technology neutral as it relates to the new ESP extend to an AP1000 or just advanced reactors?
It just, in this case, it just extends to small modular reactors.
Thank you.
It would not include a large light water reactor.
Great. Thank you for that clarification. Mr. McIntyre, Chair Mitchell asked about timelines and how 2034 is a big year for long lead resources as SMRs, offshore wind, and pumped hydro storage are all selected. Do you recall that?
I do.
And then Commissioner Duffy followed up asking about offshore wind and SMRs glide paths and how they differ. Do you recall that?
I do.
And your response to Commissioner Duffy was that work is more on the front end of offshore wind.
That is my understanding.
And were you referring to the processes of the needed geologic surveys and the construction operating permit we walked through during cross?
I was not referring to those issues specifically. Rather, I was referring to the site assessment process, the process of developing a COP, the process of developing a draft environmental impact statement. So essentially the totality of the permitting process, which ostensibly would include the types of surveys you referenced.
Great, thank you. Mr. McIntyre, Commissioner Hughes asked about whether Duke is recruiting and develop any developmental help internally for offshore wind and or embedding staff in existing projects. Do you recall that question?
I do, yes.
Right now, isn't it the company's posture that they are relying on the wind energy area leaseholders for that sort of support?
Well, it depends on what you define by support. I mean, to the extent that you are talking about development activities such as site assessment, as an example, the developers certainly have the flexibility to proceed with that work today in and of themselves. In terms of internal support, I believe it has more to do with this notion of continuing to monitor the market, help support the development and issuance of the ARFI should the commission deem that effort prudent.
Okay. Well, in the IRP and near-term actions panel, Mr. Snyder and I established that because of the shared interest between the companies and offshore wind developers, that the company will be relying on the offshore wind developers to bring significant detailed information. Is that still accurate?
I mean, that's, I think by definition, part of the ARFI process.
Great, thank you. Mr. McIntyre again, I'm sorry how I labeled these.
Okay.
Commissioner Tucker identified that Dominion procured CVOW wind energy area in 2013. Do you recall?
I do.
And he asked about whether an 11-year timeline seems like the development horizon, correct?
I can't represent that. That's exactly what he said, but I remember the questioning.
Okay. And you also correctly identified that CVOW had a 2-turbine, 12 megawatt pilot project that helped with Dominion's learnings, correct?
Yes, I do.
If it would be all right with you, can we work together to further develop that timeline a bit between 2013 and 2024? During cross, NCSEA marked the long lead pumped hydro storage direct exhibit 3, which was the final order for CVOW. You don't need to turn to it, but would you recall that that was finalized in the summer of 2022?
I don't recall that specifically,
Okay.
no.
Well, I guess I phrased that poorly and I might ask you to go to it just so it's correct in the record. I'm sorry. Can you go to potential exhibit 77, please?
Which volume?
2 or 3?
That's right. That's right. That one. Yeah. 77.
77, yes.
Okay, I'm there. Thank you.
Great, thank you. So on the top of the first page of this final order, you see that it is dated August 5th, 2022, correct?
I do, yep.
Great, thank you. And can you now flip to NCSEA potential cross exhibit 89? And Presiding Commissioner Kemmerite, NCSEA would like to mark potential cross exhibit 89 as NCSEA cross long lead and pumped hydro storage direct exhibit 4.
It will be so marked.
Thank you so much. Mr. McIntyre, this is the order on reconsideration, which is the last order in case number PUR 2021-00142 for the approval and certification of the Coastal Virginia Offshore Wind Commercial Project. Does that track?
I see that, yes.
And at the top of this page, do you see that that order was issued on December 15th, 2022?
I see that.
Great. Thank you so much. And finally, subject check, can you confirm that CVOW didn't receive its commercial construction and operating plan until January 28th, 2024?
I can't speak to the timeline of Dominion's receipt of their COP?
Yeah, I don't have a good exhibit, but it was January 2024, if we can stipulate to that fact.
Without seeing it, I would not stipulate to that fact.
Okay, well, I will try my best to follow up on that there. Ms. McIntyre, to the best of your knowledge, Dominion is now driving in monopiles are driving in monopiles at the CVL project.
That is my understanding, yes.
Great, thank you. Next, Commissioner Tucker asked about the Jones Act. Presiding Commissioner Kemwright, NCSA doesn't have any questions on this, but is asking if the commission will take judicial notice of NCSEA potential cross exhibit 61, which is the Merchant Marine Act of 1920, section 27, as amended 46 USC section 883, which is commonly referred to as the Jones Act.
I will take your request for judicial notice under advisement to see if it fits within the parameters of North Carolina General Statute 62-65B. And I will, when you make your motion, I will let you know.
Okay, thank you. So continuing on with Commissioner Tucker's question on the Jones Act and the possible constraints of how it is going to affect the development of North Carolina's offshore wind, can we please go to NCSEA potential cross exhibit 21? That should be in volume 1. And presiding Commissioner Kemwright, NCSEA would like to mark NCSEA potential cross exhibit 21 as NCSEA cross long lead and pumped hydro storage direct exhibit 5.
It will be so marked.
Thank you. Let me know when you're there.
I'm there.
Great. Can you confirm that this is the Offshore Wind Market Report 2023 edition as published by the Department of Energy?
Yes, sir.
Can we please go to page 44?
I'm there.
Okay, once I'm there, I would like to read you footnote 21. So footnote 21 says, referring to U.S. vessels as Jones Act compliant may be misleading because foreign flagged vessels can operate in U.S. waters in a Jones Act compliant manner. For instance, a foreign wind turbine installation vessel installing wind turbine components transported by a U.S. built feeder barge. Vessels that can transport cargo between U.S. ports and need to be, I'm so sorry. Vessels that can transport cargo between U.S. ports need to be built and registered in the United States and owned and crewed by U.S. citizens or permanent residents. Is that an accurate reading?
It is.
Thank you. And knowing that certain barges can transport turbine components from shore to the actual development site, should that help accelerate offshore wind deployment and assuage any execution concerns?
I don't know that I would use the word should. Again, I think that it certainly can help, but I would go so far as to say that it will.
And before you go any further with your next question, explain again the potential exhibit that you want us to take judicial notice of, and what is it, a federal statute? What exactly is it? It wasn't clear.
It is the federal statute. It is the Merchant Marine Act, and that is what is commonly referred to as the Jones Act, which I just asked Mr. McIntyre about.
And what potential cross exhibit number is it?
61.
61. Okay, thank you. You may proceed.
Thank you. Last question, and this also relates to a question on Commissioner Tucker. Mr. Capps, Commissioner Tucker asked about what is the assumed price of an SMR, and he volunteered a $1 billion price, to which you responded with appropriate qualifications That seems low for a 300 megawatt electric SMR. Do you recall?
I do.
And Mr. McIntyre, yesterday you volunteered that 2,600 megawatts of offshore wind in the coastal Virginia offshore wind project cost Dominion approximately $9.8 billion. Do you recall?
I remember saying that the estimated price for CVAL was 9.8. It obviously hasn't cost them 9.8 because it's not built yet.
Right. And Mr. Capps or Mr. McIntyre, whoever would like to take this last question, given that numerous 300 megawatt SMRs are planned, it is a possibility that the total cost of all the SMRs built could exceed that $9.8 billion mark quoted for CVAL.
I mean, based on the numbers that are represented in the plan, I would expect that to be the case.
Great. And just to confirm, Mr. McIntyre, North Carolina is only seeking to pursue 2,400 megawatts of offshore wind at this time.
That is what has been identified in our supplemental planning analysis.
Thank you. No further questions.
Okay. And before we move on to additional questions on commission questions, the commission will take judicial notice of NCSEA potential cross exhibit number 61.
Thank you.
Thank you. Mr. Neal.
Thank you, Presiding Commissioner Kimwright. Good afternoon, David Neal on behalf of SACE et al. Mr. Capps, I have a follow-up question that is also related to Commissioner Tucker's question that followed the initial discussion about TerraPower, and then he, as noted by Mr. Simolovsky, had volunteered. As I recall, do SMRs will cost about $1 billion? Do you recall that exchange?
I do.
And as Mr. Simolovsky noted, in your response, you said you thought, if I remember correctly, that's a little low, I think is what you said.
Yes, sir, that's correct.
And I'm trying to avoid having to go into confidential session. Is the actual capital cost estimate that Duke used for SMRs that, as I understand it from your response, were derived from the Idaho National Labs report? Do you know what that figure is?
I do not off the top of my head.
And
just as another point, the Idaho National Labs report is a public report, so you're more than welcome to go look at the prices and the cost.
Duke, in its generic unit summary, or GUS, would have made some adjustments to the figures from the Idaho National Labs report. Would you expect?
I do not know.
Okay. Would this be a question better asked to Mr. Snyder's panel?
It would be.
Okay. Again, without, all right, no further questions.
Good afternoon. I have just one or two follow-ups. I believe they're for Mr. McIntyre, and they flow again from Commissioner Tucker's questions, which have generated a lot of interest. I want to clear up a little bit about the Jones Act vessel, because I want to make sure that everybody's aware. Are you aware that that vessel is not owned by Dominion Energy Virginia, doing business as Virginia Electric and Power Company?
I don't know who owns it. It was my understanding that Dominion commissioned it, but I don't know who the owner is.
So you don't know if it was commissioned by Dominion, the corporately traded parent, or Dominion, the utility?
That's correct.
I'll just open it. Does anybody else on the panel know who the owner of the Jones Act vehicle, the Jones Act vessel is?
No idea. I do not.
Those are all my questions.
Thank you. To the panel, I want to just sort of step back and ask a very few big picture questions, so a 30,000-foot view on the testimony, starting with a follow-up to Chair Mitchell's questions about the size of these investments, and then some follow-up questions from Council for Sigfer on that same topic. Again, putting aside the uncertainty of the ultimate amount of megawatts of which of these resources ultimately gets selected by the commission, you all, I believe, have confirmed that these three resources generally are three of the largest capital investments under consideration for potential inclusion in the CPIRP, correct? Let me just ask that question to Mr. McIntyre to confirm on behalf of the panel.
Yes.
And again, these three resources have some of the longest lead times of any of the resources under consideration in the CPIRP, correct?
If not the longest, yes.
And that's the logic of why the three resources are being presented together as a panel, correct?
Yes.
And you were also asked questions from a number of commissioners, including Commissioner Hughes, sort of comparing and contrasting development plans for each of these three resources. And I want to follow up on that. From a high level, can each of you just briefly, again, summarize how the companies have carefully tailored the development plan for each of these three resources based on the unique factors that inform each of the resources in terms of development activities? Maybe starting with you, Mr. Capps, can you just reiterate the big picture on why it is you're proposing development activities you're proposing?
So if you think about nuclear, the company's got a long history of safely, reliably, cost-effectively operating nuclear plants. Relative to the carbon plan, nuclear fills a need for baseload dispatchable generation. And we believe the plan we've laid out is reasonable and has looked to balance the risk and the timing of permitting and construction to get us to an endpoint of start making nuclear available. But we, I would tell you, we are the top nuclear operator in the country. And so it makes sense if nuclear satisfies the need from a decarbonization standpoint, that we would have an interest in nuclear as a part of that.
Mr. McIntyre, can you also speak to how the companies carefully tailored their development plan for offshore wind?
Yeah, I'm happy to. I think as we've noted on a number of occasions, the companies do not currently own an offshore wind energy area. So we do not own a lease that we could initiate development activities within. Clearly, the supplemental planning analysis selected offshore wind as an opportunity, as a potential resource to contribute to our decarbonization goals and meeting load in the future. And so we believe that a measured risk-informed approach, absent having the ability to develop a WIA today, is the most prudent decision, and it's the right decision for North Carolina customers. That allows us to proceed in a very thoughtful, although accelerated fashion, to gather all the information that we need and that this commission needs to make an informed decision on the resource moving forward.
Thank you. Mr. Smith, could you speak to this as well?
Yeah, similar to what Mr. Capps had stated, we've safely and reliably operated long duration storage at our Bad Creek and Jocassee facilities and continue to move forward with the development of Bad Creek 2. We feel that it is prudent to do so to provide the needed storage that's needed on our system for the future.
Thank you. And a final question for the panel, I'll direct this to you, Mr. McIntyre. When will the companies be back in front of this commission with further refined information about these three resources to further inform the commission in its decision-making on these resources?
Objection. Which commission question does this come from?
We're speaking to the logic behind the company's development activities, which was a topic of broad discussion on commissioner questions.
Is the standard here broad discussion, or is it based on a specific commission question?
So, Mr. Drack, I believe that your question was specific to a commissioner's question. And so I will overrule the objection. The question actually it related to a question that I remember asking.
Thank you. And it's a very simple question. Again, when will the companies be back in front of the commission with further information on these resources to inform their decision making?
I believe in approximately a year.
Thank you. No further questions.
Okay, so that takes us to the end of questions on commission questions. And with that, I will take motions from the parties.
Thank you, Presiding Commissioner Kimmer. At this time, we would move the company's confidential exhibit number 1 into the record.
Hearing no objection, your motion is allowed.
Just a point of order, is only the confidential record going in and not the public version that was filed in the docket on September 1st, 2023?
I believe the normal practice is the commission produces both a confidential and non-confidential version of its transcript, so that the confidential information be included in the confidential version.
Right, we are, I have allowed both the confidential and the non-confidential versions.
Thank you.
Okay, motions, Ms. Kress.
Thank you. SIGFR would move its SIGFR 2 and 3 cross long lead generation and pump storage hydro direct exhibits 1 and 2 into the record.
Hearing no objection, your motion is allowed.
Thank you.
NCSEA?
At this time, NCSEA asks to move into the record NCSEA cross long lead and pump hydro storage panel direct exhibits 1 through 5.
Okay, hearing no objection, your motion is allowed. And I believe that those are all the exhibits that were offered into the record. Is that correct? Okay. With that, we've come to the end of questions on direct for the panel. So you'll be back on rebuttal, but you may step down for the day. And thank you very much for your testimony. And Duke, Mr. Brusher, I believe, before we do that, are there any preliminary matters before we call the next panel that any of the parties wish to make? Mr. Neal. I should say any motions as opposed to preliminary matters.
Thank you, presiding. Commissioner Kemmerite. It's come to our understanding that no parties have crossed for Sace et al. Witness Rampani, and that commission staff has asked whether the commission had questions and have indicated that we should make a motion to excuse witness Rampani and ask that her direct testimony consisting of 96 pages with one exhibit containing confidential information filed on May 28th, 2024 with a corrected version of the public testimony that just removed some of the redactions with the agreement of counsel for Duke be entered into the record as if given orally from the stand.
Okay. And
at the appropriate time.
Okay. And seeing no objection, your motion is allowed and it will be entered into the record at the appropriate time.
Thank you.
Okay. Thank you.
Thank you, Presiding Commissioner Kimmerite. The company calls the transmission and interconnection panel of Mr. Sammy Roberts and Ms. Jinxie to the stand, and I'll wait for them to be sworn in.
Okay. So I'll go ahead and swear you in. Good afternoon. If you can place your left hand on the Bible and raise your right hands. And do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay.
I do.
Okay. Thank you very much.
Great. Good afternoon, you both. Afternoon. Mr. Roberts, I'll start with you. Would you please state your full name and business address for the record?
Yes, my name is Dewey S. Roberts II. I go by Sammy, and my business address is 3401 Hillsborough Street in Raleigh.
And Mr. Roberts, can you pull the microphone a little bit closer to you, please?
Thank you. And
if you can.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Corporation, and my current title is General Manager of Grid and Operations Planning.
All right, thank you. And can you please just briefly describe your role and responsibilities for the company and how you've contributed to this carbon plan IRP?
Yes. So I have primary responsibility for generation interconnection studies and planning, and also strategic transmission planning. And so in that regard, my responsibility includes the support of reliable transmission transformation for the generation transition. And that includes coal retirements and integrating new renewable resources.
Thank you, Mr. Roberts. Turning to you, Ms. Shee, can you please state your full name and business address for the record?
Yes, my name is Jean Shee. My business address is 411 Fayetteville Street, Raleigh, North Carolina.
Thank you. And by whom are you employed and what capacity?
I am employed by Duke Energy as Managing Director of Renewable Integration.
And can you briefly describe your role and responsibilities at the company and how you've contributed to this carbon plan IRP?
Yes, I have primary responsibility to manage the interconnection process for the Carolinas and Florida jurisdiction. These responsibilities include administering the utility scale interconnection enrollment, study, construction, and the interconnection agreement execution, as well as the commissioning process, including the back office support for cost allocation and billing.
And when you provide further testimony, can you move the microphone closer to you so that we can hear a little bit better?
Okay,
Thank you.
Thank you, Ms. G. So Mr. Roberts, turning back to you to introduce the panel's direct and supplemental testimony. Did the panel cause to be pre-filed in this docket on September 1, 2023, direct testimony consisting of 30 pages and one exhibit?
Yes.
And did you individually also cause to be pre-filed on April 30th, 2024, supplemental direct testimony consisting of 12 pages and one exhibit?
Yes, that's correct.
And do you have any changes to your direct or supplemental testimony this time?
No, I do not.
And if I were to ask you those same questions today that appear in your pre-filed testimony, would your answers be the same?
Yes, they would.
And just to confirm, there was no confidential information identified in the panel's pre-filed testimony?
That's correct.
Thank you.
And Mr. Brushert, before you move on, can you double check to make sure that there was one exhibit attached to the direct testimony so that our records can be?
Yes, ma'am. Yeah, I've got it here. It appears you're correct, Presiding Commissioner Kimmerite. There were no exhibits. That was just with the supplemental direct testimony. So I apologize for that.
Okay, thank you.
Thanks for the clarification. Did the panel also pre-file a summary of their direct and supplemental testimony with the commission?
Yes, we did.
Thank you. Presiding Commissioner Kimmerite, at this time, I'd ask that the transmission interconnection panel's direct testimony, as well as Mr. Roberts' supplemental direct testimony, be entered into the record as if given orally from the stand, as well as the summary of their direct testimony that Mr. Roberts sponsored also be entered into the record as if given orally from the stand.
Seeing no objection, your motion is allowed. The direct testimony and Mr. Roberts' supplemental testimony, along with the summary of the testimonies, will be entered into the record as if given orally from the stand.
Thank you. And I would also mark for identification Mr. Roberts' supplemental Exhibit 1 for entering into the record at the appropriate time.
Okay. And the exhibit attached to Mr. Roberts' supplemental testimony will be marked for identification purposes as pre-marked.
Thank you very much. The witness is available for cross-examination and questions from the commission.
And it looks like Mr. Smith with Avangrid is up first.
Hi, nice to see you. Ben Smith on behalf of Avangrid Renewables LLC. I believe just a couple questions. I know I reserved 10 minutes, but I don't think it'll take that long. In your direct testimony, you talk about how at this stage in generation transition, why Duke Energy is more focused on local transmission planning and projects. Do you all consider for transmission planning offshore wind as a local project since it doesn't go over state lines, or is it regional, or how do you classify it?
So the network transmission that would be associated with offshore wind would be local. It would be part of the local transmission planning process.
Thank you. And could you just describe a little bit about how offshore wind is being considered in the transmission collaborative and some of the other processes that Duke is going through?
Yes. So I'll start with the 2023 CTPC public policy study that's already been conducted, and we have the final report posted on our website. That considered 800 megawatts of offshore wind injecting into Newbern as a point of interconnection. And then we've drafted and sent out to the Transmission Advisory Group a study scope document for our MVST, Multi-Value Strategic Transmission Study, that will look at 2,400 megawatts injected into Newbern POI, and also a sensitivity that will look at an additional 2,400 megawatts injected into a Sutton North POI.
Thank you. And I want to bring up something that came up, I think it was yesterday, that they deferred to the transmission panel on, and that's in Chapter 2 of the application on page 38, if you have that.
Okay, what document was that?
It's Chapter 2 of the application, which is methodology and key assumptions. If you don't have it, we can do the subject to check.
I don't have that.
Okay, well, would you mind doing a subject to check? I'm just going to be reading out what's in it. All right. So subject to check, the application, chapter 2 shows transmission overnight costs in 2023, dollars per watt for offshore wind beginning at 800 megawatts, 1600 megawatts, and 2400 megawatts, and showing DEP at 48 cents per 800 megawatts, 84 cents per 1600 megawatts, and 65 cents per 2400 megawatts. Is that how you recall, subject to check?
Subject to check, that sounds correct.
And what I want to know is that, did you all look at larger build-outs of offshore wind beyond 2400 megawatts?
So this is a question for the modeling panel, but subject to check, I believe they did look beyond 2400 megawatts.
And do you recall today what the transmission overnight cost effects of those larger numbers were?
I do not recall at this point.
No further questions.
Ms. Kress, SIGFUR is up next.
Thank you. Mr. Roberts, you are personally involved with the Ncpc, is that correct?
That's correct.
Is it fair to say that you are an advocate of multi-value strategic transmission planning?
Yes, I think it is. The commission in their 2022 carbon plan provided us a directive to move quickly, looking at the North Carolina Transmission Planning Collaborative Local Transmission Planning process, and look to add transparency and coordination, as well as basically a revision of the process to facilitate being more aligned with the carbon plan and what it would take to facilitate implementing or executing on the carbon plan.
Is it fair to say that the Ncpc is completely indifferent as to who will ultimately pay for the investments that it is recommending in the planning process?
I wouldn't say that we're indifferent. I mean, there's a established cost allocation methodology that's approved by FERC, and we're just following that cost allocation methodology. And when we made our FERC filing for the changes, the revisions to attachment N-1 covering the local transmission planning process, that was brought up in the FERC's discussion in their acceptance. And if I remember correctly, subject to check, they agreed that load ratio share was an appropriate cost allocation method.
Is it fair to say that the Ncpc does not attempt to parse out which customers or groups of customers may benefit from a particular investment?
That's correct. I mean, we're looking at resource portfolios. With MVST, we'll be looking at loads, large loads, that sort of thing. And so it's kind of a comprehensive long-term look at what the transmission needs will be to move us forward with respect to implementing the resource plan, as well as accommodating additional loads.
Are you aware that SIGFUR has provided feedback to the Ncpc regarding the companies no longer classifying proposed transmission investments as economic reliability or public policy investments?
Mr. Roberts, before you answer the question, we're still having trouble hearing you. Is there a way that you can really move the microphone closer to you?
Sorry.
Or figure out a way to speak more directly into it?
Any closer and I'll be eating this microphone.
Yeah.
So,
or speak up then.
Okay.
Commissioner Kimmerer, before he answers the question, objection assumes facts. The question said no longer identifying transmission planning projects by designating their usage, and it assumes that was a historical practice that no longer is used. So I think it assumes facts, not in evidence.
Okay, Ms. Kress, before you respond, can you restate your question, please?
Absolutely. Mr. Roberts, are you aware that SIGFUR has provided some feedback to the Ncpc within the last, say, 2 years since we were all before this commission in the initial carbon plan proceeding?
Yes.
And before you answer the question, do you still have an objection, Mr. Brushworth?
No, ma'am. As refined, the question is appropriate.
Okay, thank you.
Yes, I do remember SIGFUR providing feedback.
And at this time, I will ask that we get an exhibit in front of you, and that is SIGFUR potential cross exhibit number 97.
Okay.
Mr. Roberts, you said you were familiar with the fact that SIGPIR had provided feedback to the Ncpc. Were you personally involved in providing the feedback that you see here in these emails exchanged, the last one on April 6, 2023?
And Mr. Roberts, before you answer the question, let's go ahead and have the proposed exhibit marked for identification purposes.
Thank you. We would request that this be marked SIGFIR 2 and 3, cross transmission and interconnection direct exhibit number 1.
It will be so marked.
Thank you. Mr. Roberts, do you need me to repeat the question?
Yes, please.
You said you were familiar with the fact that SIGPIR had provided feedback to the Ncpc. Were you personally involved in providing this response to that feedback that you see here in these emails, the last of which is dated April 6, 2023?
Yeah, so the Oversight Steering Committee, which is comprised of the participants in the North Carolina Transmission Planning Collaborative, now the Carolinas Transmission Planning Collaborative, all the participants review any correspondence that we provide to questions that come from the tag stakeholders. And this would be an example of that.
Thank you. And do you see on the first page, the first sentence next to number 1 reads, the assignment or allocation of transmission capital investment costs to the various jurisdictions and customer classes involves retail rate-making matters that are outside the purview of the Ncpc?
Yes.
Thank you. And do you also see next to number 4 on that same page, it says, as stated in response to question 1, the assignment or allocation of transmission costs to the various jurisdictions and customer classes involves rate-making matters that are outside the scope of the Ncpc and would be best addressed through the retail rate-making process?
Yes.
Thank you. No further questions.
Mr. Smith, I believe that you're up next for Environmental Defense Fund.
I have no questions. Thank you.
NC Warren is up next.
Thank you, Presiding Commissioner. Good afternoon. Good to see you again, Mr. Roberts. My name is Matthew Quinn. I am here with NC Warren et al., and I have a few questions. I suspect most of them will go to you, Mr. Roberts, although I could be proven wrong about that. So I guess my first question is this. Are you familiar with some of the data responses that Duke made in this case concerning standard interconnection timelines for utility scale solar?
Yes, I am familiar with that. With respect to the interconnection process and interconnection timelines, I'll probably invite witness She to respond.
Okay. Then maybe I was wrong that it would be mostly you. I apologize. Well, then there's a notebook that I can get up and get for you sitting at the corner of the table, if I may approach.
Yes, you may.
There you go. That's a notebook of NC Warren's potential examination exhibits, and I'd ask you to please turn to tab 5. And this potential exhibit 5 was previously marked and moved into evidence yesterday as NC Warren et al. Cross Renewables and Energy Storage Panel Direct and Rebuttal Exhibit 3. So is this a response to data request that you're familiar with?
So it looks like witness Farver of the renewables panel responded to this data request.
Okay. Yeah. Have you ever seen it before?
I have not.
Okay. Does it sound right to you, this statement in this response to data request, that the standard interconnection timelines for utility scale solar have been reduced to 20 to 21 months for projects without significant network upgrades?
I'll invite witness She to respond.
Yeah, so in 2022, we were looking into opportunities to optimize the post-interconnection agreement construction phase of the life cycle. So we looked into if there's opportunity to standardize some of the interconnection requests that does not require network upgrades. That is an outcome of that, the 20 months is for interconnection requests that requested an in-service date that fit into that time frame, and it does not require network upgrades. It only requires single-phase circuit breaker to build the interconnection facilities. So all those three factors come into whether we can deliver in 22 months. But if the developer does not request 20-month delivery, then that's not happening.
Okay, I understand. So this 20 to 21 month projection deals with interconnections of utility scale solar that don't involve significant network upgrades, basically.
Correct.
Now, most of these interconnections for utility scale solar, though, are going to require a significant network upgrade, though.
From what we have seen.
Okay.
Yeah.
Yeah. Okay. And I mean, can you ballpark what the percentage of that is? I mean, it's more than half, right?
50% is going to require three years to construct from the IA executed.
Okay. Which is considerably more than the 20 to 21 month projection.
Yes.
Okay.
Because they require network upgrades.
Yeah. And these network upgrades, they're pretty expensive, right?
They are, but it dependent upon, the location of the interconnection request. If they chose to select site into the constrained area, it's going to require network upgrade costs.
Yeah.
And network upgrade, some of those could take long time to build.
Yeah, so there's both, for these interconnections of utility scale solar, more often than not, there's both a high cost and a long lag time associated with it.
Depending on, again, the siting. If they're located in remote areas or the constrained areas, which is the red zone, we're familiar with that terminology in this case, then yes, there will be required network upgrade. And that's not unique to Duke Energy. A lot of transmission providers are experiencing the same thing.
Are you at all familiar with the grid improvement plan that has been put forward in the multi-year rate case in front of the commission?
I am not very familiar to it.
Mr. Roberts?
Yeah, I am not.
Okay. Then I will hold that then. Now, these upgrades that are required for interconnection of utility scale solar, that's at least in part because of the need to add large power transformers to the network when you interconnect, right?
Large power transformers?
Yes.
I would say no.
Okay. Is there a need to step up voltage from the point of interconnection to the transmission system when you interconnect?
From the point of interconnection to the transmission system, I would say no.
Is there a need to add transformers and high voltage breakers in order to create these interconnections?
Once again, from the point of interconnection to the transmission system, I would say no.
In order to, well, there's been a lot of talk about the red zone, and especially in the last carbon plan doc, but also in this one. And there's been talk about network upgrades required to accommodate this utility scale solar, right? You're familiar with those discussions?
Yes.
Okay. Now, does Duke have any sort of plans for new transmission lines, whether in the near term or in the long term, in order to accommodate this new utility scale solar?
New transmission lines, as in greenfield, acquiring right of way, siting, permitting. Not for connecting new generation, new resources, not network transmission. No.
Okay. All right, I have no more questions. Thank you.
NCSEA, you're up next.
Thank you. Panel, may you please turn to page 41 of Appendix L.
Okay.
And on page 41, in the offshore wind section, it beginning reads, completing transmission projects to support interconnection of offshore wind as a diverse resource in the resource plan portfolio will be challenging from a timing and scheduling standpoint. To enable offshore wind interconnection to DEP system, new right-of-ways and major transmission construction will be required, involving supply chain, siting, permitting, and construction risks, as well as risks associated with acquiring the right-of-way. Delays in these scheduling dependencies are key risks in meeting any timeline for importing offshore wind energy. Did I read that
Yes,
correct?
you read that correctly.
Understanding those schedule dependencies, what is the latest that offshore wind projects need to be entered into the DICES to maintain the current 2034 timeline to interconnect offshore wind?
Yeah, so we have a good understanding of the network transmission that will be needed. We have the 800 megawatt injection study from CTPC. And then we have other information associated with going beyond 800 megawatts with a new 500 kV line that will be needed. So if you're talking about the network transmission piece of that, we have a pretty good understanding and cost associated with that network transmission.
Okay. And since you brought up the CTPC and that there's an 800 megawatt injection from offshore wind, understanding that 2.4 gigawatts of offshore wind is now projected in the P3 cases, the CTPC is now updating that study as part of its MVST to accommodate that injection rate.
That's correct. One of the MVST scenarios proposed that's in the draft study scope document is 2,400 megawatts injected into New Bern POI.
Thank you. And that the results of the MVST are scheduled, the preliminary results of the MVST are scheduled to come out in Q2 of 2025 before the next carbon plan?
So before the next carbon plan, that's correct. Our plan is to study and identify the needs by the end of the year, identify needs, and then solutions will be proposed by March, April timeframe, and then we'll look at alternate solutions.
Thank you, Mr. Roberts. And you mentioned the 500 kV and AC transmission lines from New Bern to Wake County. And even though those are going to help inject offshore wind, it is also true that other interconnecting resources can benefit from those new upgrade transmission assets as well.
That's correct.
Thank you. No further questions.
Next in line for cross-examination, SACE.
It's perfect. Okay, Nick Jimenez with SELC for SACE et al. Oh, thank you, my colleagues handing out the notebooks. So I'm going to start with some questions about battery and solar interconnection limits. And I'm going to try to avoid retreading ground too much that we covered in Duke's Rule 30b-6 deposition, where Mr. Roberts was a designated witness. So I'm going to try to use that to move us along. If we can start with I'll start by referencing an exhibit. I was going to introduce this, but it's already been introduced as SACE et al. Cross IRP NTAP Direct Supplemental Exhibit 1. This is the portions of the 30b-6 deposition that Mr. Quinto was responsible for. And I'm getting a quizzical look. Okay.
Can you state again which potential cross exhibit it is so that we can find it?
Okay, so this is SACE et al. Potential Cross-Examination Exhibit 24.
And can you, for the record, can you state what SACE exhibit it was that was entered into the record?
It was entered as SACE et al. Cross IRP NTAP Direct Supplemental Exhibit 1.
Thank you very much.
Do you have that?
In one of these books, I presume.
I think just the exhibit. If it's easier to go right to potential cross-examination exhibit 24, that's probably the way to go.
Okay.
Okay, so do you recognize that as a response to a data request submitted by public staff 28-2?
Yeah, the response was composed by witness Quinto, or it can be represented by the modeling panel. But so I won't be familiar with this unless I read through it.
Okay. Why don't I give you a minute to read 28-2A, because I want to talk about the factors in there.
Okay.
Okay, so would you agree we've got impact to, and these are the factors considered when setting the annual interconnection limits, correct?
For standalone storage, correct.
We've got impacts to forecast global stationary battery storage equipment and construction services markets. And well, I'll ask you if you're following with each one.
Yes. Anything pertaining to the forecast global equipment and construction services markets would be better referred to the renewables panel.
Okay. The second one we've got is availability of locations on the transmission system requiring relatively low upgrades to facilitate new firm interconnection, right?
Yes.
And cumulative effect of interconnection construction, cumulative effect on interconnection construction volumes. And the fourth one here, potential for further storage technology development and price declines over the long term.
Okay.
That's all right. Okay. So I realize that you've said that some of these would be better for the modeling or the renewable panels. To the extent you can respond to them, of course, I want to understand what these mean. One thing I understood from Duke's 30B6 deposition was that there was no study underlying these standalone battery storage interconnection limits. Is that right?
Presiding Commissioner Kimmerer, just to confirm, Mr. Roberts has identified that the extent of his scope and responsibility, and as it relates to this data request that he's not seen previously, is limited to the interconnection provisions of this data request. I just want to be clear that the other panels are sponsoring the other aspects of this data request, and so his testimony doesn't pertain to that. And I think he's testified he doesn't have any knowledge of what's stated here in the data request.
Okay, would you like to respond?
Well, I'm asking witness Roberts about interconnection limits, and he was one of the designated Duke witnesses to respond to this topic during his 30B6 deposition.
Right, and Mr. Quinto was, excuse me, as was Mr. Quinto, who sponsored this data request. So as long as your questions pertain to the scope of his expertise, which is solar or interconnection limits, that's appropriate. But global supply chain, the battery storage market, that testimony would be beyond the scope of what Mr. Roberts testified to today or in a prior deposition.
Okay, so I will note that the person that responded to this data request is witness Quinto, who has already testified, and witness Quinto is not testifying on this panel. You may ask the questions, Mr. Roberts, if asked to the extent that you're able to do so based upon your expertise and your direct testimony, to the extent that you're able to do so.
Okay, thank you. So I'll answer your question about are there extensive studies with respect to interconnection limits? I mean, batteries on the system are very like it says, location determines the upgrades, right? And so you go through a DICES study and the generator customer puts in their request. We study it, see what the upgrades are associated with that. There's also studies done by our battery group where they, just like consultants that work for developers, can take the models that are available and they can run studies. Use the PowerGen Terra tool, and they can run studies to see what types of upgrades could be created by placing a battery at a certain point on the system. And so it's developing interconnection limit through that type of study. No, we haven't done that.
Okay, I want to push on that a little bit. If you'll turn, this is in the deposition. So again, that was introduced as the IRP NTAP cross exhibit 1. If you'll turn to page 260 of that deposition transcript.
Okay, I've got it. Okay. I'm sorry, what page was that?
260.
Okay, I start with my deposition on page 262, so I don't have 260.
Okay.
And we're having some trouble hearing you. Can you
Oh.
pull the microphone closer to you? And can
sorry.
you identify the potential cross-examination exhibit so that we can find it?
Okay, I think this is all, all potential cross exhibit 1 should be the entire deposition.
Okay. Okay. Okay, and I see that this was still the deposition of Snyder and Quinto.
That's right. Well, it was Duke's 30B6 deposition to be precise, but when they were responding.
And before we go any further, we're going to need to identify the
I'm sorry.
the exhibit.
Presiding Commissioner Kimmerer.
Yes,
May I? So-
you may be heard.
So I think we covered this with Mr. Neal on the IRP and NTAP panel. The company objects to the introduction of the entirety of this deposition transcript to the extent, I mean.
Yeah, that's my mistake. That's not what I meant to do.
Okay.
Just this page is fine.
Okay, and
Or these two pages.
I'm sorry. It seems appropriate to, if you have a question to pose to him, and if it is informed by something he said previously, to use for impeachment or some other purpose relevant to the hearing, but to point him to the deposition transcript, which then to ask questions about, seems a little backwards to me.
If I can respond.
Okay, please respond.
It is for impeachment, which is what we've agreed to. Witness Roberts alluded to a bunch of studies that could have been performed to underlie these interconnection limits. And the transcript here shows that there were no studies.
Okay, so I'm going to allow you to ask questions related to specific pages of the deposition. I'm trying to flip through and determine how many pages the deposition is. I mean, it looks like I haven't gotten through all of 564, a number of pages. So what we would need to have you do is file a new exhibit with just the specific 2 pages. And that you're going to be referencing. And then after it's been filed on Monday, you can make a motion to have it, that exhibit admitted into the record.
Okay, thank you. We can just. Presiding Commissioner, should I mention now that I would mark this as SACE et al. Cross transmission interconnection panel direct exhibits 1, I suppose.
And I'm sorry, just can we be precise about what you said this? What
Sorry.
specifically are you proposing to mark?
Yeah, yeah.
Pages,
Please go ahead and identify which pages you intend to mark and then file with the commission.
understood. Pages 260 to 261.
Okay. So we will mark as SACE et al. Cross transmission and interconnection panel number 2, which is to be identified for purposes of the transcript as proposed Exhibit 1, pages 260 and 261 of proposed SACE Exhibit 1. Is that correct?
Yes.
Okay. And the process will be that we will not be making a ruling upon admitting this proffered Exhibit number 2 into the record today. It can be filed, and then on Monday, you may make a motion to have it admitted into the record. The 2 pages 260 and 261. So we need to have the actual exhibit that is going to be Exhibit number 2 filed with the commission.
Okay.
Okay, thank you.
Just go ahead, Brett.
Thank you. And just to confirm that as I read these pages, there's no testimony from Mr. Roberts identified on these pages. So it may be more proper to wait and ask the deponent who answered the questions during the deposition, or ask a general question versus trying to impeach a witness who didn't make a statement.
So let's take just a minute for me to get to pages 260 and 261 so I can see what witness has spoken, is testifying.
And I apologize for bogging us down, but this just seems to be a pretty fundamental point that we haven't navigated before. And if we're going to start using deposition transcripts to impeach witnesses, it should be the witness who answered the question during the deposition.
Since we're waiting, just to respond to that, I mean, this again is a 30B6 deposition, and both witnesses were designated for this topic.
So I'm going to sustain the objection. Mr. Snyder will be available on rebuttal. And so the question related to testimony that he provided in his deposition can be asked to him at that time when he comes back up on rebuttal.
Okay. Witness Roberts, I'm going to stick with proposed Exhibit 1, this deposition. If you will turn to page 269.
Okay.
You'll agree this is where you were testifying, correct?
Yes, that's correct.
All right. Do you see where you were discussing the battery energy storage development team?
Yes.
You see on lines 6 to 7 where you say theirs was more of an assessment as well of market conditions.
Yes.
Do you see on lines 16 to 17 where you say, and there's an economic decision there?
Yes.
And that refers to interconnection of batteries, if you look back at lines 12 to 13, right?
Yes.
Okay. So that economic decision was made by the interconnection team, right?
So the economics with respect to connecting batteries are looked at from several points of view. My understanding is they have to look at the potential PTC production tax credit, or excuse me, the ITC investment tax credit associated with batteries. They have to compare that against what the ICIS reveals for network upgrades. And I'd like to clarify the study piece as well. The study I was referring to that the battery development group performs is for an individual battery. It's not for a group of batteries, so it doesn't propose a limit, interconnection limit.
Okay. I would move to mark, or I would mark page 269 of potential cross exhibit 1 as SACE et al. Cross transmission and interconnection direct. I'm not sure now.
We will call it Exhibit 2.
Two.
Exhibit 2, and that again will be, should be filed with the commission. You can make the motion sometime next week, whenever is best.
Thank you.
Commissioner Kimmerer, I'm sorry, I'm going to object to this exhibit as well. I mean, Mr. Roberts is here. He's answered the question to the extent of his knowledge. The commission has heard his direct testimony. So what he said in a pre-filed deposition that it doesn't seem, it seems unduly cumulative and in excess of what a deposition transcript is contemplated to be used for under the Public Utilities Act, which refers to what depositions are appropriately used for in Superior Court. So the witness is here. He's available. If Mr. Jimenez has a question that he can answer within the scope of his testimony, I think that's very appropriate. But to refer back to things that he may have said without context in the context of a deposition that the commission wasn't present for and didn't hear seems unduly cumulative, unnecessary, and in excess of appropriate use of evidence under Rule 403 of the Rules of Civil Procedure. And so, or excuse me, the Rules of Evidence. A little rusty on my Rules of Evidence these days, but I do think that is unduly cumulative and unnecessary to put this page of the transcript into the record, especially if we're going to start doing this throughout the entire hearing.
Okay, so Mr. Rushworth, I note your objection. SACE is not, I don't need to have a response from you yet because SACE is not moved to have it entered into the record. You may make that objection when he files when and if he files the exhibit with the commission and then ask for it to be entered into the record, and you may make your objection at that time.
Thank you.
Okay. I think we can move to solar interconnection limits. Understand where those came from. Do you remember, I guess, do you agree with your prior testimony that you said the solar interconnection limits were derived from averages from the 2022 phase 2 DECs?
So the solar interconnection limits or availability that was input to the CPIRP modeling, is that what you're referring to?
Yes. Well, yes.
Okay.
I'm talking about the limits that are on in chapter 2 on page 31, and then in the supplemental planning analysis that were updated a little bit in the supplemental planning analysis.
Okay. I think we're on the same page.
Okay. Do you agree that the solar limits were derived from 2022 phase 2 DECs?
So the solar availability as described in Appendix L was derived looking at executional and operational risk associated with the increase in transmission line outages that would occur with each additional incremental solar facility interconnected to the system.
Okay. So I'm not sure that answers the question whether they came from the 2022 phase 2 DECs.
The 2022 phase 2 DECs, there were 3 phases to that DECs restudy phase. The 2022 phase 2 DECs looked at the generators that were still in the queue, transitioning from phase 1 to phase 2, and what transmission impacts were associated with that study of those resources still requesting interconnection to the system. And so if you look at that phase 2 study report, one for DEC, one for DEP, you will see the resource requesting interconnection and you will see the associated network upgrades for interconnecting that resource at that location.
Okay, I'm sorry to press on this, but I think you were explaining to me the 2022 phase 2 DICES. I'm trying to understand where the limits that Duke used in the carbon plan came from, and if they came from that.
So as stated prior to the discussion on the phase 2 DICES, in Appendix L, there was an analysis associated with executional and operational risk by increasing transmission line outages in order to interconnect a certain amount of interconnections of solar. And so the phase 2 DICES was used in development of that analysis, in that we looked at the average sizes of the state projects and FERC projects in each area, DEC and DEP. And that from that derived a number of interconnections to get to a certain break point of annual interconnected solar. So in that regard, the 2022 DICES was associated with that analysis.
Okay. So would it be fair to say the solar interconnection limits were derived from a generator-driven process?
The solar interconnection, you had to have a basis for the number of interconnections. The 2022 DICES was used as a basis for the number of interconnections you could expect on an annual basis to get to a certain target level. And so based on that number of interconnections, there are 6 transmission line outages on average per interconnection. And so you can estimate the number of additional transmission line outages you will have to accommodate on an annual basis to interconnect a given level of solar.
So would you agree that a generator-driven process kind of underlay the solar interconnection limits?
It was an input to the analysis.
Addressing transmission upgrades proactively lowers risk and accelerates interconnection timelines, correct?
That's correct.
And forward-looking planning lowers costs, right?
I would agree with that generally.
Okay. Now, shifting gears, I have some questions for you about the Southeastern Regional Transmission Planning CERTEP process.
Okay, I would just go ahead and state on the record that I'm not a participating Duke member of CERTEP at this point in time.
Would that be Bob Pierce?
Bob Pierce is one of our participating members, yes.
And he's in your transmission group?
Yes, he is.
And you're the general manager of that group?
That's correct.
So he reports to you?
That's correct.
Okay. And you sponsored Appendix L?
That's correct.
If you'll turn with me to page 16 of Appendix L.
Okay.
Do you see the discussion at the bottom of page 16 of CERTEP and public policy requests in the last full paragraph and the beginning of the next one?
Yes.
I'll try to avoid rereading that. Do you recall that?
Yes.
Okay. Now I would like to mark SACE et al. Potential cross-examination exhibit 39 as SACE et al. Transmission and interconnection direct exhibit 3.
It will be so marked.
Yes.
Okay.
Do you see on page 139 of that potential exhibit? That's the only page we need to look at, really. Oh, I should ask you first. Do you recognize this as a CERTEP, meeting slides, CERTEP document?
It has Southeastern Regional transmission planning on it, 2023, and it's dated June 29th, 2023, preliminary expansion plan meeting.
Thank you. Okay, so I'll give you a minute with page 139 if you're there.
Yes.
So there were 3 public policy requests submitted, correct?
I'll take your word for it. That's what it says here.
We'll both take CERTEP's word for it.
Yeah.
Do you see where it says, in the second bullet, in accordance with the NCUC order, the North Carolina Carbon Plan order is currently being considered by Duke Energy and in activities of the North Carolina Transmission Planning Collaborative, NCTPC?
Yes.
And do you see in the last bullet where it directs submitters to the NCTPC's Transmission Advisory Group, or TAG?
Yes.
Okay. And you see at the top, this is 2023.
Yes.
Okay. Now I would like to mark SACE et al. Potential cross-examination Exhibit 40 as SACE et al. Transmission and Interconnection Direct Exhibit 4. If you'll turn to that, please.
It is so marked.
Potential Exhibit 40.
Okay. Okay.
And do you recognize that as another CERTEP document?
It has the Southeastern Regional Transmission Planning label on.
Have you ever seen it before?
No, I have not.
Okay. If you'll turn with me to page 4. Do you see stakeholder proposal number 5?
Yes, I do.
Okay. And I can give you a minute with this. But does it look like the same thing happened?
Yes, it looks like it refers the submitter of this PPR back to the CPC.
For a public policy study request associated with the carbon plan, right?
That's correct.
Okay.
And before we go on with additional questions, we've come to our afternoon break. So it is 3:01. We'll go off the record now, and we'll come back about 3:11. Thank you.
I'm gonna
Okay, let's go back on the record and we'll continue with cross-examination questions from SACE.
Okay. So we've been talking about public policy requests that were submitted by entities that were not Duke, right?
The one you referred me to, stakeholder proposal number 5 was by Southern Alliance for Clean Energy.
Duke didn't
And
submit.
Mr. Roberts, can you speak up again?
Yes.
Thank you.
Sorry.
Duke didn't submit any public policy requests, right?
To CERTEP?
Yes.
Not that I'm aware of.
And you would be aware if it had, right?
I would think Bob would inform me. Yes.
Okay. So to kind of I'm hoping you can help me understand CERTEP's decision. Duke is a sponsor of CERTEP, correct?
We're a participant in CERTEP. That's correct.
Okay. And Duke, that means Duke participates in CERTEP's evaluation of public policy requests, right?
As a participant of CERTEP, if that's one of their functions, which I would think it is, then yes.
You said earlier that you're not a Duke's representative on CERTEP anymore. So you used to be.
No. No, I've never been a Duke representative on CERTEP.
Okay. Can you detail the process CERTEP uses to make decisions like these?
No, I cannot.
You don't know if there's a vote?
I do not.
When you don't know if when a public policy request relates to a specific utility, like this one, you know, CPIRP request relates to Duke, whether that utility decides?
I do not.
You don't know if it provides a recommendation?
If a utility provides a recommendation?
Under those same circumstances where a public policy request relates to that utility in particular?
I do not.
Okay. So in any case, what we've seen here and what it says in Appendix L is when public policy requests relating to the CPIRP have been submitted to CERTEP, it says we're not going to study them because Duke is studying them and the CTPC is studying them, correct?
Presiding Commissioner Kimmerer, objection. I'm not sure that's stated anywhere in Appendix L. Ask counsel to reframe the question.
Before I do so, would you like to respond to the objection?
Well, again, I've been trying to save time. I mean, we covered what Appendix L says, and I asked the witness to refresh himself on it. I think that's a fair paraphrase, but
Okay.
counsel doesn't.
So to keep this moving along, can you just rephrase your question?
Would it be fair to say, based on what you've seen in the exhibits that we just covered and on pages 16 to 17 of Appendix L, that when a CPIRP public policy study request has been submitted to CERTEP, CERTEP has not taken up the request and has directed the submitter to the CTPC tag?
I don't know. I mean, what it says in Appendix L is that Ncpc is studying a portfolio of resources suggested by the 2022 resource plan, which is referring to our 2023 public policy study. And any resulting transmission plans will subsequently be made part of the CERTEP process.
Right. So it didn't take the request up, right?
The CTPC?
CERTEP.
The way I'm reading this, no, CERTEP did not.
Okay, and how about the appendix that you sponsored? If you look at the bottom of page 16, you see where it says CERTEP's response to the public policy requests indicated that in accordance with the NCUC order the carbon plan order is currently being considered by Duke Energy and in its local planning activities with the NCTPC.
Yes, you read that correctly.
Okay. The NCTPC, now the CTPC, studies local transmission projects, correct?
That is correct.
And I'm pulling from attachment N1 here, which I believe you're familiar with. A local transmission project is a transmission facility that, among other things, is not selected in the regional transmission plan for purposes of regional cost allocation, right?
That's correct.
So the CTPC public policy process would not be the right place to study the regional aspects of the CPIRP, would it?
So I believe attachment N-1 also says if the CTPC, through its studies, reveals something of a regional nature, then that will be moved up to the regional transmission planning process.
Okay, no further questions.
Mr. Creech, public staff is up next.
Right. Good afternoon, Mr. Roberts and Ms. Shee. Good to see you again, Mr. Roberts. Saw you down in Charlotte at the deposition, just sitting in on that. We've reserved about 30 minutes, but I think it's going to be much less than that today. And so just for a moment, I want to talk with you about the RZEP 2.0 projects. And as you may know, I think you know that this is a matter, these red zone expansion plan projects are items about which the public staff and the company have not been able to reach settlement. Is that correct?
That's my understanding, yes.
Okay. So that's why we're going to have this conversation here today. In your direct and supplemental testimony, you discussed and identified ultimately seven RZEP 2.0 projects, and those are in North Carolina and South Carolina. Is that correct?
That's correct.
And 3 are in DEC territory, and then ultimately 4 are in DEP territory. Is that correct? Subject to check.
Subject to check, yes.
Okay. And just as in your supplemental testimony, you added the 7th project, which is the Lee Milburn rebuild in DEP. Is that correct?
That's correct.
And do you have any update that you want to provide on that since the time of your testimony on this?
Yes, I can provide some update. So I'll start really from the beginning of going through and developing the RZEP 2.0 projects, and that we used the 2022 DICES Phase 1 studies, looked at the upgrades needed to accommodate a high volume of solar in both DEC and DEP, and essentially looked at the list where you had multiple solar facilities that impacted a given constraint, and you didn't have 1 or 2 solars that if you remove those, that constraint would go away. And so these candidates for RZEP 2.0 projects would enable a lot of solar facilities in DEC and DEP. And we talked with transmission planners extensively with respect to the potential to enable large amounts of solar, made sure that they were good candidates for proactive transmission, and they agreed. And then also we were conducting the 2023 public policy study through the CTPC, and that was that study was performed to validate the need for these projects, that they were indeed going to reflect as overloaded transmission, and thus were good candidates to pursue in a proactive manner. And
I was going to ask you about the Lee Milburn rebuild in particular, but you know.
Okay. And the results of the CTPC 2023 public policy study did reveal all of the RZEP 2.0 candidates, including the Lee Milburn, which was on the original candidate list, but wasn't included in Appendix L. It showed all of those RZEP 2.0 projects as overloaded in the study. And that study looked at 12.5 gigawatts of solar. It looked at a little over 2 gigawatts of batteries. It looked at solar paired with storage. It looked at 800 megawatts of offshore wind. It looked at 2 combined cycles, 4 CTs. It essentially lined up somewhat decently with the P3 fall base case, even though it was a modified P1 from the 2022 carbon plan portfolio. But for 12.5 gigawatts of solar and solar paired with storage, those constraints, RCEP 2.0 constraints, were identified as overloaded facilities in that study. And so it validated the need for those RCEP 2.0 projects.
My question was, you have any update on the Lee Milburn rebuild though in DEP?
Yeah, so Lee Milburn, while I was alluding to the study, is the study did show the Lee Milburn as an overloaded facility, and if I remember correctly, subject to check, the 2022 DICES Phase 1 revealed that there were 1,600 megawatts of solar facilities that were dependent on that upgrade.
All right, now let me take you back just one second. So we've talked about the Ncpc, and that's a FERC kind of mandated so-called local transmission collaborative, and that's comprised of Duke, DEC, DEP, Electricities, and Ncmc. Is that correct?
That is correct.
And that's in North Carolina and South Carolina. It's now called the CTPC. Is that right?
That's correct. It's called the Carolinas Transmission Planning Collaborative.
All right. And then the regional one is the CERTIP, which y'all were just talking
That's correct.
about. Is that right? All right. Now, I want to talk a little bit about the North Carolina, South Carolina piece here. You've talked about how these projects are in North Carolina and South Carolina, and you've asked that the commission here acknowledge these RZEP 2.0 projects. And so I guess my question is, it's kind of a bifurcated question here, is when you're asking for acknowledgement, are you asking for de facto approval? And relatedly, are you also asking the South Carolina Commission for acknowledgement of these projects, as you are here in North Carolina?
Yeah, so when we're requesting acknowledgement, network transmission is a FERC jurisdictional thing. And so similar to the 2022 carbon plan for the RZEP 1.0 projects, we're just asking for acknowledgement from this commission that these projects are needed to execute our resource plan. But for these projects being pursued proactively, we won't be able to meet the targets in the resource plan.
You're not asking for approval because the approval actually comes through the Ncpc. That's that in the working groups of that local planning collaborative.
That's correct.
Okay.
Similar to the RZEP 1.0 projects, the Oversight Steering Committee comprised of those entities you talked about, DEC, DEP, Electricities, and Ncmc. We review the study results and other factors, and we include those in the annual local transmission plan, and we have to vote on and approve that local transmission plan.
And that's not occurred yet,
That has not occurred.
All right. Now, back to my question. You've asked the North Carolina Commission for these North Carolina, South Carolina projects. You've asked our North Carolina Commission for acknowledgement of this. Are you doing the same in your IRP proceeding in South Carolina?
So in South Carolina, we are requesting acknowledgement of the NTAP, the near-term action plan, which includes those RZEP projects.
But you're not specifically asking, it's a broad ask. Is that what you're saying?
Once again, the NTAP includes the RZEP 2.0 projects.
All right. And I am going to have just one exhibit, if I may, and I'm going to use the ELMO. We've talked about ARF and ELMO here. This is public staff potential cross exhibit number 7, and it's a public staff data request to do, but I only have one of the data requests that I would like to enter, and this is a non-confidential page. This would be public staff data request number 46. And so let me ask you to grab the folder there at the end of your table.
Hey, Mr. Creech, would you like to go ahead and mark the exhibit for identification purposes?
I would, please. This would be Public Staff Cross Transmission and Interconnection Direct, Exhibit 1. And it's actually, I think it's this other big one.
I
You
think
got
I
it?
have it in here.
Okay,
And Mr. Creech, it'll be so marked.
thank you. And this is page 4 of 17 for potential cross Exhibit 7. And this is a single data request and response, non-confidential.
What item was that in PSDR 46?
Yes, sir. 46-4.
This is the one that's.
And Presiding Commissioner, just as a point of clarification, Mr. Creech and I spoke about this, and I think that the entirety of the set included confidential information, but my understanding is this individual data request is not. So just to clarify that for the commission.
That's correct. And this is all I'm asking to enter into the record today, just this one page.
And this is page, which page did you say, Mr. Creech?
I believe it's page 4 of 17.
And if it's helpful to the commission, it's you can mark it as data request 46-4 to the companies.
That's right.
So, Mr. Creech, we have as proposed, public staff proposed cross-examination exhibit number 7 as a number of pages and is marked confidential. So if you can file your exhibit 1 with the commission, which would be page 4, proposed public staff cross-examination exhibit number 7 that does not have the confidential marker
Yes,
included.
Absolutely.
Okay, thank
Certainly.
you.
All right. And this will be kind of the final piece. And so are you familiar with this data request and response, Mr. Roberts?
Yes, I am.
All right. And so let's see here. Let's just look at the request. It says describe at the top. It says describe if it is likely that a 230 kV network line could reduce the need for DEC's proposed RZIP 2.0 projects, Broadway, Bush River, and Champion. And then it says if a 230 kV network line could not resolve the proposed projects, please explain why. Do you see that?
Yes.
All right. Now, if we go down actually to your response and we go several lines down, it says to this point. Do you see that? Go down to the 1, 2, 3, 4, 5,
Yes.
6. It says to this point, there have not been any studies performed to allow identification of specific new 230 kV projects. Is that correct?
That's correct.
All right. No more questions. Thank you.
Okay, thank you, Mr. Creech. Redirect from Duke.
Thank you, Presiding Commissioner Kimmerer. A few questions, and wanted to start with a few acronyms just to clean up for the record and for the commission. So I think Mr. Roberts, you and Mr. Creech worked through CTPC and SERTP pretty well, but maybe just briefly reiterate for the commission what those planning processes are, please.
Yes, CTPC is the Carolinas Transmission Planning Collaborative, and as Mr. Creech referred to, it is composed of Duke Energy Carolinas, Duke Energy Progress, Electric Cities, and Ncmc. And recently, the local transmission planning process, which is the Carolinas Transmission Planning Collaborative, filed revisions with the FERC, and they were accepted, and we are implementing those changes. Part of that change is to make sure the name doesn't imply it's North Carolina only. So Carolinas Transmission Planning Collaborative, and it's we're making sure that other load serving entities understand that they can join as participants on the Carolinas Transmission Planning Collaborative.
Thank you. And you also, there is some reference in the cross-examination to MVST. Would you spend just a minute or two speaking to what that is?
So that was part of the filing of the revisions to the local transmission planning process. MVST stands for Multi-Value Strategic Transmission. And that process is going to be more forward-looking. It was endorsed by FERC as being forward-looking and basically a almost a first mover in that area for a local transmission planning process. And it's going to look at scenarios. It's scenario based. And so you're not just focused on one portfolio or one scenario. And it's also going to look at multiple benefits. And so it doesn't just look at the, like our current cost benefit analysis that we do for RZEP projects, just looks at reliability and resiliency through our asset replacement model. And so we're going to look at multiple benefits, quantify those benefits, and that will help us identify the best no regrets proactive transmission to pursue.
Thank you. And earlier in the examination from Counsel for NC Warren and then briefly with Counsel for Public Staff, there was some discussion about the red zone projects. Do you recall that?
Yes, I do.
And I think Mr. Quinn asked something to the effect of, are you building new lines to solve the red zone? And you responded that no, the company's not planning new transmission lines, or new greenfield lines that require new permitting and right of way. Do you recall that discussion?
Yes, I do.
Okay, and a key component of your testimony is speaking to how the company is seeking with the commission's acknowledgement to resolve the red zone. Is that fair?
Yes.
Okay,
That's
and
correct.
can you speak to what those red zone projects are? I mean, they're rebuild projects. Is that an accurate characterization?
Yeah, one of the projects in DC is transformer replacement project. And then the remaining projects are line rebuild projects, reconductors, essentially.
Okay, and can you articulate for the commission the value of those projects to the system and why, in the company's opinion, they're needed to solve the red zone and are part of the proposed plan and request for relief from the commission?
Yeah, so one of the ways to articulate the value is through cost benefit analysis. And we perform cost benefit analysis for all 7 projects, and it's reflected in supplemental table 1 of my supplemental testimony. And that shows that all the benefit to cost ratios are 4 or above. And the average is, if you average these, is with the NPVs and the estimated benefits, it's 17. And that was provided in a data request response.
Thank you. And so the way you assess these cost benefit analysis is asset replacement. So it's reflective of the reliability value to the system.
Right.
Is that
so? All of these assets are aging equipment and really old based on where they're located on the system. And so we're replacing that aging infrastructure with new infrastructure. And so that helps with reliability for customers as well as resiliency. And that's what the asset replacement value model gauges with its cost benefit analysis.
okay? And that supplemental table you mentioned, that's on page 9 of your testimony?
That's
your
correct.
Supplemental direct testimony?
That's correct.
Okay. And each of those 7 projects the company is recommending were cost effective for customers?
That's correct.
Okay. And I think you also mentioned in your response to questions from Mr. Creech about the 2023 public policy study. You recall that discussion?
Yes.
And just to clarify for the commission, can you articulate how the company, with input from the public staff, as I understand it, developed that public policy study and presented those 7 RZEP projects or assessed the cost effectiveness of those RZEP projects?
May I interrupt just for one moment? I don't objection only, or point of clarification. I didn't ask that question. He may have stated in response to a question I had, but I don't know who it was.
Okay, that's fair enough. I think in the examination of Mr. Creech's examination, the topic of the public policy study came up and was discussed. And so I am seeking to clarify Mr. Roberts' response.
You may proceed.
Okay, thank you. So just if you could spend a minute explaining how the company developed that public policy study and explain the role the public staff had in developing the public policy study, please.
Right. So on an annual basis, for the You're referring to the 2023 CTPC Public Policy Study, correct?
Yes, sir.
So on an annual basis, the CTPC collects public policy requests for input to studies for that year. And that's just part of our annual process. That's transitioning to MVST studies, but for 2023, it was still the public policy request part. So we received public policy requests from several entities, including the public staff. There were diverse public policy requests. And so through discussions of the parties that submitted the public policy request, we agreed to a modified P1 portfolio, P1 being the 2022 carbon plan portfolio. And we agreed on the resource mix to be analyzed. And the main goal was to look at 12.5 gigawatts of solar and additional solar paired with storage. And so that's the portfolio that was studied. And in that study, it was presented to the Oversight Steering Committee and CTPC, as well as the TAG, several times, that one of the purposes of the study was to validate or invalidate the RZEP 2.0 projects were needed, and to evaluate if additional projects were needed to be added to the proactive RZEP 2.0 list. And so the results of that study, as I mentioned to Mr. Creech, revealed that the RZEP 2.0 projects indeed overloaded with that portfolio, and the Lee Mill Burney, which was on the original candidate list, also overloaded. And so that's how the RZEP 2.07 projects are in our request for acknowledgement by this commission.
Thank you. And so the request for acknowledgement by the commission, you had some questions from Mr. Creech about approval versus acknowledgement. And essentially, the company is making the same request to the commission that the company made in the initial carbon plan proceeding related to the RZEP 1.0 projects. Is that accurate?
That's correct.
And the company understands that approval of these projects occurs through the FERC jurisdictional local transmission planning process. And so the request you're making here is to recognize that these RZEP 2.0 projects are needed and beneficial to the system to execute the carbon plan IRP on the timeline that's been identified as presented in the NTAP and the execution plan.
That's correct.
Thank you. No further questions.
So I just have a couple. I think that Commissioner Duffley has a fairly long list of questions, but just to follow up on a couple of questions. Mr. Roberts, you've testified that you're not asking for approval from the commission for RZEP 2.0, just acknowledgement for the need for RZEP 2.0. If you're not asking for approval, why do you need acknowledgement from the commission? You're going to be proceeding through the CTPC regardless, is my understanding. Is that correct?
That's correct.
Okay.
It's basically a recognition that these RZEP 2.0 upgrades are needed in order to execute this resource plan.
Okay.
Is what I'm asking for.
Okay, and so even without the acknowledgement, you'll be proceeding with the CTPC approval process or request through the CTPC.
That's correct.
Okay. And so I guess I'm trying to understand why it's necessary from Duke's perspective that the commission provide any acknowledgement, since we're not providing any approval.
Right. I mean, in this proceeding, we're talking about the integrated resource plan and the execution risk associated with the resource plan, the ability to implement the resources in the resource plan. And so just having this commission's acknowledgement that this is part of the resource plan, these RZEP 2.0 projects, in order to execute it, is what we're seeking.
Okay. And then also, can you respond to, I believe it was Public Staff Metz's concern that he stated, I believe it was either Public Staff Metz or Thomas, their testimony was that they thought it was premature for the commission to even provide acknowledgement because the CTPC had not fully vetted the RZEP 2.0. Can you respond
Yeah.
to that concern that it's premature for us to even provide acknowledgement of need?
Yeah, I think it would be lopsided if we got CTPC approval of the projects and then came to the commission for acknowledgement. That's kind of backwards to me. So we're basically proceeding on a similar process as we did in the 2022 carbon plan, where we're seeking acknowledgement, and then we'll finish out the CTPC process and get approval from the OSC and the CTPC that they need to be included in the 2023 or 2024, 2034 local transmission plan.
And then my last question before I let Commissioner Duffley take over, and I'll probably have a few more questions on Monday. But you mentioned the cost benefit analysis for RZEP 2.0 was 4 or above, and I believe you said 17?
Average of 17.
Average of 17?
Yes.
Yeah, do you recall what the cost benefit analysis for RZEP 1.0 was, if you recall?
I do not off the top of my head. I know they were all above 1.
Okay. Okay, and so Chair Mitchell has a question before Commissioner Duffley.
Just one, it'll be quick. So I want to make sure I understand the information the public staff has put into the record from 46.4, the data request response, Mr. Roberts, that you looked at just a minute ago. So the RZEP 2.0 project list includes 3 projects for DEC, is that right?
That's correct.
Okay, and each of them is 100 kV, involves a 100 kV line, right?
That's correct.
Okay.
Well, one is a transformer replacement project, and the other 2 involve 100 kV lines.
Okay. So the public staff's question in this data request, as I understand it, is did the companies look at, or did DEC look at a 230 kV line to resolve the constraints that are of concern here? And is that how you understood the company or the public staff's question?
Yes. I will state that there were 3 potential solutions that weren't associated with the RZEP 2.0 projects that were in the report. And I think that's where the confusion is. One of those was a 230 kV greenfield line in the DEC area. And so what we agreed to in the 2023 report is in this 2024 MVST study to look and see if there truly is a need for a greenfield 230 in that DEC area. And so we intend to focus on that with this MVST study cycle.
Okay, so the upcoming study will look at what the impact of the 230 line in this area.
Right.
But what does that mean for purposes of these 3 2.0 projects?
Right. Once again, the 230 kV greenfield line, that was not put forth in the 2023 study as a solution, alternate solution for the RZEP 2.0 projects.
Okay, so so is it the case then that these 3 RZEP 2.0 projects for DEC would still be needed to resolve the constraints irrespective of what y'all learn about the 230 kV line?
Yes, based on the study results and other analysis conducted internal. Yes, that's
Okay.
correct.
So then just help me, just make sure I'm entirely clear on why your response here says, we didn't study a 230, I'm paraphrasing, didn't study a 230 kV line. A 230 kV line here would require right-of-way acquisition and et cetera.
Right.
So just walk me through the response.
So we
given
know
here.
that the RZEP 2.0 upgrades identified are going to be needed to continue to meet our targets on solar and solar paired with storage, especially in the DEC area. The one thing pursuing, if our study shows a 230 kV line is needed for, all the resources in the portfolios in the MVST study, greenfield transmission has high risk associated with it. In that, like it says, you've got to secure right-of-way permitting, siting permitting, and you can have opposition such that you can't move forward with it. And so we can't the RZEP 2.0 projects identified in DEC are upgrades that will enable us to move forward with meeting those targets identified in the resource plan.
Okay. All right. Thank you, Mr. Roberts. I have nothing further.
Commissioner Duffley.
So before I get to my questions, I just wanted to clarify the record. I think you responded that the average cost benefit analysis on page 9 was 17 and it was actually 13. According to your testimony, has it been revised?
So in a data request, it was revised.
Okay, thank you.
Yeah.
And then with respect to the 230 kV greenfield line that we were just discussing in the DEC area, would that be in North Carolina and South Carolina or just one or the other?
So the Greenfield 230 was specifically associated with South Carolina and the Duke Energy Carolinas area. For North Carolina, 500 kV Greenfield Solutions is what we'll be looking at.
Okay, thank you. And then Commissioner Kimmerer asked you about the request for acknowledgement. And I'm also trying to fully understand that because before the carbon plan, it was just the Ncpc. I mean, you didn't come to this commission, correct, before you went forward with a line until you came in for a rate case? Or can you just describe that process pre-carbon plan for me, please?
Yes. So the process we took with RZEP 1.0, is that what you're asking?
No, I'm talking about pre-carbon plan. So pre-RZEP 1.0, just your typical like 10 years ago.
Okay.
When you're going through the process, there was no request for acknowledgement at the commission before moving forward. Everything was handled with the Ncpc.
That's correct. And pre-carbon plan, most projects were driven by TPL 001 reliability studies, asset management programs, or interconnection studies, or a generator request interconnection, and the studies reveal a certain upgrade needs to be constructed. So that's how projects were driven, FERC approved processes. The proactive transmission process that was initially presented to the commission in the October 2021 technical conference on the 2020 IRP. It's a different process, and it's just needed that it being associated with the IRP, that we get acknowledgement in this proceeding from the commission that those projects are needed to execute this IRP.
Okay, thank you. And in the interest of time, I'm going to switch around my questioning. I was going to ask you, just so you know, maybe we'll do it on rebuttal if we get through the rest of my questions today, but I'm going to ask you about grid enhancing technologies.
Okay.
And what the company's doing. But if we could turn to, well, first, in your direct testimony, you updated the commission on the last status report of the CTPC process. And since that time, the companies have filed a new status report in docket E-100 sub 190T dated July 18th of 2024. For purposes of this hearing, is there anything that you would like the commission to be made aware of from that report?
So the cost of RZEP 1.0, we even added a project, the Camden DuPont 115, to get from 14 to 15 RZEP 1.0 projects. But the cost has gone down. Originally, I think it was in the neighborhood of 550, maybe north of 550 million. Now it's around 503 million. So those costs have gone down. The projects are still on schedule, and all the projects will be completed by mid-2027. As far as the CTPC process, we are proceeding with a 2024 MVST study, and that study will look at 3 scenarios. Multiple scenarios were submitted by the tag stakeholders. and the OSC reviewed and has 3 in the study scope document that is being reviewed by the tax stakeholders at this time. One looks at a very aggressive P1 portfolio. We know it's not executable, but we're going to look and see. That kind of gives us a picture for a longer term, right? If we're still doing a 10-year study, but we're looking at the P1 portfolio, that kind of gives us a picture of beyond 10 years of what transmission will need. And so we're also looking at P3, and we're looking at some offshore wind scenarios as well.
So with the RZEP 1.0, there was a project added. Can you please tell me the status of that project?
Yes, the Camden DuPont 115, subject to check. I believe the schedule for that is to be completed in 2025. And is there other information you're requesting on that project?
No.
All I know at this time.
If there is, we'll ask you on rebuttal.
Okay.
How about that? So if you could turn to page 3 of your supplemental testimony, and specifically lines 19 through 22. So I was going to talk to you about gets before getting to this question, but we'll start here. So you've stated with this new line, the Lee Milburnie 230 kV line, that you're using a 1500 MCM aluminum conductor steel reinforced, or ACSR, or an equivalent aluminum conductor steel supported with trapezoidal wire. Am I correct that an ACSR in the industry, that's a traditional conductor and not really considered an advanced conductor?
You're correct.
Okay. But maybe the trapezoidal component might be kind of dipping into an advanced conductor space.
It is considered an advanced conductor.
Okay. And why did you not choose an advanced conductor?
So we very well may be going with the ACSS trapezoidal wire in this construction.
Okay. And have you placed any advanced conductors on the North Carolina system or South Carolina system?
Yes, we've applied ACSS trapezoidal wire in certain projects, reconductor projects.
Okay, about how many projects?
I don't know the number total.
Percentage?
I don't know a percentage. I would hazard to guess a percentage. I know that if you look at our DICES, a lot of the reconductor projects associated with upgrades are ACSS trapezoidal wire.
Okay, so it could be that most of your reconductoring that you're doing right now has this advanced reconductoring or advanced conductors.
Yes, I would say that's correct.
Okay. And on page 4, line 4, you discuss that replacing aging infrastructure will provide reliability and resiliency, and you say which will benefit around 1,400 customers. And you're using the word aging infrastructure.
Yes.
And what I want to know is this line in the structure at the end of its life? And if not, how many more years of life does this structure and line have?
Right. So for the 157 wooden H-frame structures, they are near end of life. And if our subject check, if I remember correctly, that's a 40 to 45 year life. And so those would be replaced with steel H-frames and or monopole steel construction. And then I believe the whole line is any infrastructure that hasn't been replaced. Like if we had a wood pole that had to be replaced we put a steel bowl back in its place. But the majority of the line is 1979 vintage equipment.
Okay, and how about the wire?
That's 1979 vintage, a lot of it. I won't say all of it.
Okay, and then could you explain to me, just for this one project, what's the exact driver for this rebuild?
Yeah, enabling 16, the DICE study showed 1,600 megawatts of solar that was dependent on this upgrade. And you've also got other resources in Eastern North Carolina. If we have onshore wind in Eastern North Carolina, if we have batteries in Eastern North Carolina, if we have offshore wind in Eastern North Carolina, all those resources will take advantage of this upgrade.
Great, and you anticipated my next question about when you mention on page 5, you talk about other generation, and so that's the other generation that you're speaking of?
Yes.
And there'll be enough excess capacity with the rebuild and reconductoring of this line to accommodate those other generations sources that you're discussing?
Up to a certain point, yes. I mean, if
Okay.
we,
How much excess generation do you expect?
I don't recall, I think I have it in my testimony somewhere, the MVA, additional MVA that will be gained by reconductoring the line, but it's substantial.
Okay. And then if you could turn to pages 7 through 9 of your testimony. And I believe I understood your testimony to state that you were using a cost benefit analysis to support the RZEP 2.0 projects. And could you just describe a bit further the asset replacement value model?
Yes, so it's receives a lot of inputs from SMEs in our company associated with the age of the components, infrastructure making up the line. It can look at things like past CMI, customer minutes interrupted associated with the line, a lot of different data inputs in order to gauge the probability of interruption to the customers. And from that, compares that a value associated with those interruptions based on the customer class, customer types. And it compares that to the lowered interruptions associated with the new infrastructure.
Okay, thank you. And then turning to your chart that on page 9 regarding the cost benefit analysis. So if the CBA is over 0, the project has some benefit. Is that my understanding?
So if it's a 1, CBA of 1, the benefits are equal to the cost.
Okay.
For anything above 1, the benefits are greater than the cost.
Great. And I'm a lawyer, so can you help me with the math? How high can the CBA number go? Is it to 100?
It can go as high as the benefits that are calculated versus the net present value of the cost, the net present value of the benefits versus the net present value of the cost.
So what could that range actually look like?
I don't know how high it could go. I mean, you've got one on here you've got a lot of important customers fed by the Clayton Industrial Selma line, and that's reflected by replacing that aging infrastructure with new infrastructure, and it gives a benefit to cost ratio of 34.
Right. And so I'm just trying to figure out the range, like how much higher could it go, or could it go above 34?
I assume it could go above 34, but I don't know how high it could go. I don't know if there's a limit based on the benefits. I mean, it's limited by the costs are fairly well determined, and the benefits based on this probability of failure are fairly well determined. And so I don't know how high the benefits could go relative to the net present value of the cost.
Okay. So, but 4 seems lower than 34, right? In the range. Okay. And then on page 9, looking at this chart again, I just kind of wanted clarification about what is considered within the cost benefit ratio, how you calculate it. And let's use Lee Milburn line. So, as I understand it, the total project cost is 137 million. But we have the estimated cost in this as 96 million, and it does say reconductor, so it doesn't say the rebuild.
Yeah.
Is it that the calculation is just looking at the reconductoring piece and not the entire project?
No, it looks at the entire project. So the 96.3 million compared to that 137 million cost estimate you referred to, that reflects discounted cash flows.
Oh, the present. Okay, yeah.
Yeah.
Present
Yeah.
value. Okay. Thank you for that. I can save the rest on the rebuttal, but no. So in the interest of time, I'll save the rest of my questions, and I do have some staff questions. So staff, I have not forgotten your question, but I'll ask them on rebuttal.
Okay.
We'll be coming back for additional commission questions on Monday morning, so we'll have opportunity to ask those questions then. So thanks to everyone. Are there any matters that need to be addressed before we recess for the day? Okay. If not, thanks to everyone, and we will resume at 11 o'clock on Monday morning. We'll go off the record.
Thank you.